and government reimbursement program matters. Her experience includes the development of ongoing management and comprehensive HIPAA compliance programs, drafting and negotiating business associate agreements, developing internal policies and workforce training modules for patient privacy and data security, and providing advice and guidance and representation in investigations before government regulations and related to data breaches. So we're so glad that she can be here. I'll go ahead and turn the time over to her. And like I said, please, if you have any questions, please put them in the chat box. Thank you.
Well, good afternoon. Thank you all for joining us today. And I am in Birmingham, Alabama. So I'm on the other side of the country. But I have to say it's been a rainy day here. So I feel like we're in Washington. We've had so much rain this spring. But I'm very happy to be here with you. One of the things I do, as she discussed, is provide advice to a lot of healthcare clients on HIPAA privacy and security and breach notification requirements, and also the investigations that may result from a breach. So the first part of what we're going to do today is talk about HIPAA and those areas. Well, I'll also talk about HIPAA in the current environment that we're in right now, where we are all required to work remotely, and we have the more frequent use of telehealth and how that's implicated around HIPAA. And then after that, we're going to move into part 2 and talk about all the changes that have occurred there. Part 2 had nothing going on for decades, and all of a sudden we've got 3. We had an amendment of the regulations and the proposed rule and a final rule, and now we've got the CARES Act that's made some changes too. So a lot of activity there. And then the last thing we're going to close up with is 21st Century Cures Act and how that affects all the providers and what your requirements are there, and how that also overlaps with HIPAA, because there's a significant amount of interplay between the two regulations. So it's going to be kind of a marathon, and we'll take some breaks. So don't worry about that. But we'll take breaks. If you have questions, be sure to put them in the chat box. And then at the end of the HIPAA section, then we'll answer questions on that. And then after part 2 as well. And then during the 21st Century Cures Act, we're going to take a break between interoperability and the information blocking sections. And so you can have might have some time to ask some questions during that time as well. And then of course when it's all concluded. So let's go ahead and get started. Okay, let's go a little bit about my firm there. So HIPAA has basically four different areas that it covers: privacy, security, breach notification, and enforcement. There are two people that are really in charge of HIPAA. Alex Azar, he's the Secretary of HHS, and we've heard a lot from him lately. And then Roger Severino, he's Director of OCR. So the Department of Health and Human Services is the governmental enforcement, is a governmental agency that implements and puts into place the regulations, and then the Office of Civil Rights enforces the regulations. So HIPAA was initially enacted in 1996, and it was enacted as a way to try to help solve some problems with regard to how claims were submitted. At that time, it was like the Wild Wild West. Everyone could submit a claim for reimbursement in any way, in any form they wanted to. So there was a lot of fraud activity going on, and the government tried to come up with a way to help resolve that and standardize the electronic transaction process. So that's what HIPAA originally was put into place for. 2002, in 2003, the privacy and security rules were enacted and implemented. And then later on, we had some other changes as well. So in 2013, that's when HITECH was finalized and the final rule was issued, which had a significant impact on HIPAA. Later on, we're going to talk about the 21st Century Cures Act. So I think that when we look at the history of health information, HIPAA was really the first regulation that was put into place that governed and controlled the privacy and security of health information. And then HITECH came along and made some significant changes, both in in that area, but also in how information is transmitted and the regulation of what the electronic processes are regarding the transmission and the uses and reporting regarding health information. And so, and then now we've got the 21st Century Cures Act, which we'll talk about at the end of the day. Okay, so HIPAA was put into place to protect, patients' rights to privacy, but also their rights to access the records and to amend the records and get an accounting of who has accessed and used the records, and also to non-retaliation in the event that they want to make a complaint regarding HIPAA. So it protects patients' information from unauthorized use, access, and disclosure. It's enforced by the Office of Civil Rights. And one thing that you need to be aware of is that while HIPAA is the primary rule we were talking about today, almost every state has a privacy and security rule in place. Some of those are more strict than HIPAA, and those are all enforced by the state attorney generals. And those areas of enforcement are becoming more and more active. Okay, so when we go through today, we're going to talk about the privacy rule first, then we'll go into the security rule, the breach notification, and the enforcement rule. And the enforcement rule is a rule that establishes the civil money penalties and the fines, and then also other parts of what may be put into place in the event that OCR determines that there's been a violation of HIPAA, and the covered entity or the business associate needs to take some action. So I like to look at HIPAA as sort of a, like the food triangle, giant triangle. And at the bottom of it, you have the policies and procedures. And those are really the basis for the HIPAA compliance program. So you build on top of that, and you have the, the privacy rule, which addresses really how you can use and disclose and access information on a daily basis and in your operations. And then you also have on top of that the administrative safeguards. And those again are the the security policies and rules that you put into place concerning how your staff and your business associates can access and use information. Then following that, of course, you'll have the physical safeguards, which and that is, physically your structure, your the building, where you have your laptops and desktops, how that information, how those devices are tracked and monitored. And then the last thing is the technical safeguards, and those are the safeguards you put into place in your network, in your software programs that govern the integrity, availability, and security of your patient's information. Okay, so HIPAA has there's really 3 different types of penalties for HIPAA. The one that we're most familiar with, of course, are civil penalties, and those have been modified recently to take into account the fact that not all the violations are the same. Originally, the maximum penalty for all violations was $1.5 million per year, whether it was a violation that was committed intentionally and willfully, or if it was something that was unknowingly done. So they've made OCR in its discretion was able to adjust those and make some changes that do really take into account the fact that if you violate it but you didn't realize you were doing that, then you can have a lower fine. And there are some criminal penalties, and those are occasionally used. There have been a few people that have been in prison, but most of those are definitely for times when someone has intentionally accessed information for the wrong purpose, primarily to commit identity theft. Okay, so HIPAA only protects one specific type of information. As providers, we collect a lot of different types of information, financial information, demographic information, but HIPAA only protects what's called protected health information. So that is any kind of individually identifiable health information, and it can include the demographic information and financial information of the patient, but that has to be tied directly to health information. And that's the information that relates to either the past, the present, or the future physical or mental health or condition of a patient. There are several different examples. The rule provides examples of what it considers to be protected health information. This is not exclusive. There may be other things that may be included in health information, particularly if you provide dental services. There may be certain photographs and things that could be identifying that may not necessarily be identified on this list. So this is an example of these are the types of things that could be included in protected health information. Something to be aware of is that the government doesn't necessarily, OCR doesn't necessarily consider something to be de-identified if it just has, if only the name is omitted. So even a combination of some of these that do not include the patient's name could still be considered to be identified information by OCR. Okay, we talked about protected health information. There is some information that looks like health information but is not PHI. So in employment records, when you have, as a business, you have employment records. Records of your employees that may include health information are not PHI, are not regulated by HIPAA. Those are things like FMLA, sick leave requests, workers' comp information. The disclosures about, if you have disclosures within the employee about fellow employees or family members that relate to health status. De-identified information is another one that is not included in PHI, and that is something that's frequently done, and definitely not pet records. I have 2 golden retrievers. We spend a lot of time at the veterinarian's office, and someone had asked me one time about pet records, and I was like, no, they're not. That's not health information. It's only human information. So anyway, but they're so some things that may look like health information are not PA, are not protected by HIPAA. Okay, so only PHI is protected, but then HIPAA only regulates covered entities and business associates, and that is not everyone. So so if you're a healthcare provider or a health plan or a clearinghouse, and you submit claims or other information electronically through what's called HIPAA covered transactions, then you're a covered entity. Now, some healthcare providers do not submit claims electronically. Some are on, only take private pay. And for those healthcare providers are not covered entities. And a business associate is also a defined term. It's someone who provides a service on behalf of a covered entity that requires that they create, receive, maintain, or transmit the protected health information of the covered entity. So these include things like attorneys are frequently business associate because they have to access the patient's information if they're providing assistance to a healthcare provider that involves patients. And then obviously, like the electronic health record company, anyone that provides your IT services and has to access your information, cloud hosting providers for sure. So a covered entity is, again, a healthcare provider furnishes bills or pays for healthcare services products. And they have to transmit the PHI in a HIPAA electronic format. So this is a claim, payment, a COB, eligibility checking, those types of functions. And the business associate is someone who provides, they're called covered functions. Those are provides functions that relate to the actual transmission of electronic health information. Then you have professional service providers, like accountants, consultants, attorneys, someone who might do data analytics services for you. And then also the companies that maintain and transmit the protected health information for you. They're your EHR companies, health information networks, the cloud hosting vendors, data centers, IT vendors, other people that we don't think about, but that are also business associates or people that handle the document shredding, those types of services. The other thing too is that a subcontractor and that's someone who contracts with the business associate to provide a function that involves accessing your patient information is also a business associate. These are some other examples. As a healthcare provider and a covered entity, you can also be, there are times when you may also be a business associate. So we do have a lot of providers that will provide medical director services, that provide training at other facilities, help them develop their policies or maybe a process. For instance, like an anesthesia service, my anesthesia provider might work with the hospital, helping them develop their policies and processes for delivery of anesthesia services. And in doing that and training the hospital's employees, they are a business associate. So there may be times when, as a healthcare provider, you're also functioning as a business associate. But there are times when you're not. So if you are, for instance, you're providing call coverage at a hospital, you're not a business associate. You're providing healthcare services, but just at that facility. So there are a lot of times when a healthcare provider, like a lab, for instance, contracts with other healthcare providers to provide healthcare services. In those cases, you're not a business associate. Okay, so as a healthcare provider and a covered entity, there are times when you have to disclose information to a business associate. And so the question is, when can you do that? And that's only after you've executed a business associate agreement. And one of the reasons why we sort of highlight this is this has become one of the biggest issues, or one of the top issues of enforcement for the Office of Civil Rights. They still, to this day, when there are several enforcement decisions that have been released over the past year or so that point to the fact that a business associate agreement was not in place with a business associate, and so it resulted in a pretty large fine for that covered entity. And what may be disclosed to a business associate? You can only disclose the minimum amount needed, but you can also rely on your business associate to tell you what that amount might be. Okay, so a business associate agreement is required to have certain parts, certain provisions in that. And among those are that the business associate must agree to safeguard the PHI when it's in possession, must agree to comply with the security rule, and that any use and disclosure to another vendor must be within the scope of the BAA. So one thing to note is that a vendor is considered to be a business associate based on the fact that it engages in certain activity that touch the patient's information. So just because there is no business associate agreement in place with a vendor does not mean that it would not be considered to be a business associate. That's frequently happened with IT vendors when we've found that when sometimes there's a breach and there's been an investigation, an IT vendor may not have a contract with the covered entity or with the hospital or the practice, and that itself is a HIPAA violation. So it's important to review all your vendor activities and vendor engagements. Determine if the vendor is actually touching and accessing patient information, or if it has the ability to do that, and then to have a business associate agreement in place. Okay, there are certain uses and disclosures that can be done without patient authorization. Treatment, obviously, if you're a treating physician, you're sharing patient information as part of a referral with another physician. You can share that information without obtaining the patient's authorization. For payment, healthcare operations, and those are activities you can engage in to do quality review. Reporting that's needed for payment purposes and other things, peer review processes, all those types of operations you have to engage in as a covered entity and healthcare provider in your operations. Disclosures of business representatives and business associates, disclosures also to personal representatives. And it's important in those types of situations to verify the identity of the personal representative and make sure that it is, a legal position, and then also, or a family member and friend. Okay, and this is just a breakdown of some of the different areas of treatment, payment, and healthcare operations. Okay, and there's some areas that you can also disclose outpatient authorization. Those are if it's required by law. So, for instance, like right now, it's required to report some information to the state for, for COVID patients, public health activities, judicial and administrative proceedings, and those are, subpoenas or other things that relate to a legal action. Workers' comp. So if you get a request for records from the workers' comp, your state workers' comp action, then you can provide the records without requiring authorization. For abuse, neglect, or domestic violence, and a lot of states have mandatory reporting for those different types of activities. Health oversight activities, law enforcement, and for law enforcement and those, we'll talk in a minute about part 2, but there are some restrictions on what you can and cannot disclose. And also for certain information about deceased patients, and then for cadaver, organ donation, and then other ones include for research purposes in certain circumstances, and that's if there's an IRB or the patient has authorized it. If there's an IRB that waives the patient's authorization, then it can be disclosed without the patient's authorization. And other times are to avert serious threat to health or safety, which is one of the issues right now with disclosing patient information in the COVID, that relates to COVID, is how much can you disclose, and this is one of the exceptions that's being used. And then for specialized government functions. For all of these, we're going to talk a bit about one of the patient rights, and that is for an accounting disclosure. So anytime you have any of these, although it doesn't require a patient authorization, you have to record in the patient's record that the information has been disclosed and for this purpose. And that is so that later on, if the patient requests an accounting of the disclosures, you can indicate to the patient that the information was disclosed for those purposes. Okay, so for healthcare operations, there are some examples: case management and case coordination, certified organization, quality improvement and reviews, activities, peer review, business planning, development, and legal or auditing activities. Okay, patient authorization. HHS has been, they've over the years have changed somewhat their guidance on this, but in general, what they want to see is that it's something that's in writing and signed, that it's in very plain language, and what they look for is something that, around the 6th grade reading level, so that it's easy to understand and that a patient can understand it and read it. They ask that you specify what the PHI will be used for or disclosed, and then also who will be disclosing or receiving the PHI. So in this context, we're going to talk, when we go to the 21st Century Cures Act, we'll talk a little bit about those privacy practices and also your authorizations, so you can make sure that we're going to make some recommendations about maybe updating those to account for the new rules under the 21st Century Cures Act. The authorization should also have an expiration date. It can be something like 5 years, or it can be a shorter period of time. That's really up to you. And then you have to inform the patient of his right to revoke the authorization. And one of the things that we typically include on those is that, the patient can come in and revoke the authorization, disclose information at any time. But if it's revoked, that doesn't mean that you have to go back and recover the information that's already been disclosed. So the notice will typically let the patient know that that information, once it's revoked, the information has already been disclosed pursuant to an authorization will remain disclosed. It can't be recovered and changed. Okay, so HIPAA governs PHI. only regulates PHI, protected health information. It only regulates covered entities and business associates. But also part of it is that you can use and disclose information for certain purposes, but it really has to be limited and governed by the minimum necessary requirement. So you have to limit the amount that you use to disclose only to that amount that's necessary to do the job, and to those who have a need to know. So one of the things the rule points out is that you need to have basically an inventory of your workforce and identify other employees, who's able to access information and for what purpose, and then also what the restrictions are on that. So this minimum necessary requirement, though, does not extend to any disclosures that are made to the patient or to someone that the patient's directed that the information go to. They're pursuant to an authorization. They're not required to, does not apply to, disclosures of the patient himself or to the Department of Health and Human Services, or disclosures that are required by law, except for some that to law enforcement. So it's a good idea before you disclose any information, whether someone's leaving, if you have to send out a text reminder, for instance. The rule allows you to send texts of appointment to remind patients of their appointment. So it's a good idea to make sure that the information that goes out in that text reminder is very limited. When you're talking to a patient in an open setting, just make sure that you understand that the information has to be limited and needs to be taken into account the fact that others may overhear it. So think about, what information do you have to disclose to your job? Do you share this are you sharing the information with someone else, and do you have the authority to do that? What's the least amount of information you need to do your job? And the other thing too is to access only the information that's needed, share only information with those who need it to do their job. Okay, so patients have certain rights, and that is right now the Department of Health and Human Services has a directive to try to really enforce and help improve patients' rights, and that's really something that's been going on now for about 18 months. And because of that, we've seen an increase in, I guess, investigations that relate to patient complaints regarding their rights, and also we've seen an increase in the number of enforcement actions that are published that relate to penalties enforced based on patient rights to access. So the first one is that the patient's right to receive a copy of the Notice of Privacy Practices. One of the things that is, I guess, right now that is part of the proposed rule to amend HIPAA is to remove the requirement that you keep a document that affirms the patient received the copy. But still, for right now, that's still in place. So the patient has the right to receive a copy both at the commencement of treatment, and then also anytime that you amend your policies or and that amends your privacy practices. Anytime it's amended, then you need to issue a new Notice of Privacy Practices. They have the right to request that they be communicated with in an alternative confidential manner. They have the right to access and receive copies of the records. They have a right to request an amendment to any PHI that's in the designated record set, and then also a right to request an accounting disclosures. They have a right to request restrictions, limitations on use, and disclosure of PHI. You're not required to agree to all of those, except in this instance that a patient has paid for treatment out of pocket in full. In those cases, you do have to agree to that restriction, but as far as the other ones are concerned, you can use your professional judgment in deciding what is the best course of action to take. A patient has the right to file a complaint with HHS and with your office, and then the patient or hospital. The patient also has the right not to be retaliated against. So for all of these things, the patient has, the patient has the right to make the request. For not for all of them, you're not required to respond, and I mean, you're required to respond. You're not required to agree to each of these requests. So there are some exceptions. So the right to access. So the patient has the right to request access both with regard to the amount of records they want to receive, the form in which they want to receive it, and so required to provide that to the extent you can. You have to do that within 30 days, or some state laws have a shorter time period, depending on where the patient resides. And then you're also limited in what you can charge for that. So when you're responding to a patient who's requesting that they receive the records themselves, you're only allowed to charge them the cost of reproducing and delivering the records, and that's a limited amount, maybe less than what the state limit is. OCR says no, you can't charge them a fee per page, but it has to be the amount, the cost that it would cost to reproduce and deliver the record to them. And if it's electronic, they have like a little capped fee, which is about $6.50. If there's a request to deliver the record to a third party, there's been a change in their guidance, which happened as a result of a lawsuit last year, and that so the guidance was removed, and now if the patient's requesting a record that a record go to a third party, you can charge the additional cost that it that you may have incurred to deliver that to a third party, like for instance a law firm, and then but most likely there's a state cap fee that would also apply. Okay, system authorizations we talked about that in a few minutes ago, have to have specific requirements. You have to describe the information that'll be disclosed, who's authorizing disclosure, who the patient wants the information to go to, what the purpose of disclosure is, the expiration date, and also it must be signed. And then one of the biggest things is it has to be in plain language. Okay, so for persons involved in a patient's care, there are different rules. You can disclose the information to a personal representative because they're the person who stands in the shoes from a legal standpoint of the patient, and that's a guardian, conservator. It may be someone who has power of attorney that's designated under a healthcare directive. So those are the legal representatives for the patient. And in the case of a deceased patient, it would be someone who's the administrator of the estate of the patient. And so you would have to make sure that you request and receive the proper documentation from each of these to make sure that you have your address, you're providing the records or giving the information to the correct person. The family, friends, and other people can also be involved in receiving information from a patient, or from the provider regarding a patient's care, or be in the same room with you when you're providing the information. The patient has the option to object to that, and that can be done orally. So it's always a good idea if others are in the room with the patient to make sure that it is okay with the patient for you before you disclose the information, and get that document. If the patient objects, make sure it's documented in the record. Okay, so incidental disclosures. These are things that happen because you're working in an environment where there are other people around you, and there's not much you can do about that. So incidental disclosures happen all the time. Usually it's when you're in a room, like in a surgery center, you may have several patients in bed with only a little curtain between them, and so it's frequently patients will overhear other conversations. So you just have to make sure that you talk in a low tone, try to keep the information that's disclosed at that point to the minimum necessary, and avoid talking to a patient in a public setting, like in the hallway, in the lobby, in an elevator. or other place. Okay, so social media use. This is something that's gotten a lot more attention over the past couple of years. And there was a dental practice that was fined by OCR because the physician responded to a negative review on social media, and obviously that's not permitted. So anytime you want to, either respond to a patient's information, that if a patient says something that that you feel needs to be responded to, the best course of action is to do that privately. To communicate with the patient in the way that patients indicate they prefer to be communicated with, and do that in a private manner. You can post some things on social media as long as you have the patient's authorization. If you have patients that love you and want to give great reviews, then as long as you have their authorization, you can post that on your page, your Facebook page, or wherever. But you have to have an authorization from the patient prior to doing that. One thing that we've seen a lot of is, just because people have cell phones with them all the time, there are times when patient information is inadvertently posted. It could be, you might be having a Christmas party or a Halloween party at the office or in the hospital, and everyone's dressed up and you're taking pictures, and unknowingly a picture of a patient or their information's in the background, and that gets posted on social media. So just be very careful about how you use your cell phone and what you do with social media and posting of information. Okay, I think it's kind of funny. So everyone wants to have their policies and procedures in place, and they've got them posted on the intranet so you can read them and you get trained on them. But do you really have to read them and follow them? Well, the answer is, of course, yes. You have to. So as an employee, the employees of all of your organizations need to understand that it's very important that they read the rules, attend the training, understand and ask questions if they don't understand. But there's things that all the employees can do to protect patient information. That is, one thing is just treat the information as you would want your own information treated. Use the golden rule of information treatment. Don't discuss patients' information or discuss or talk with patients about their care in public places. Don't leave patient information in common areas. Don't look at patient information unless it's required to perform your job duties. If your sister's sick, or your aunt, your great aunt, don't look their information up because you want to make sure that they're being taken care of. That's not permitted. Don't take record time without training and authorization. There are too many times there are records that get stolen or lost, or a laptop gets stolen. It might have patient information on it, and that always results in an unfortunate requirement of having to make a breach notice. And then the other thing is, in areas where you have common patient treatment areas, make sure you close the curtains and speak really softly when you're discussing procedures or diagnosis. Always log off and lock your unattended computers. Dispose the patient information properly. We're still seeing a lot of instances where patient records just get thrown in the trash can, and then of course that's discovered later on, and then you have to make a breach notice. Keep laptops and other portable devices locked when they're not in use. We've seen an increase in thefts. It went down for a while, but now it's kind of seeing some of that happening again, where there have been break-ins into offices, and some of the laptops or desktops that are not attached are being stolen. So make sure your doors and desks are all locked, and secure your laptops and mobile devices. And I guess the last thing, the most important thing really, is protect your user ID and your password. Don't let anyone else have those and share them. Okay, so just some additional safeguards that you can put into place are to properly dispose of the devices or equipment. So we have, we're always, we use our cell phones, we get the next one comes out, we want to get the next brand new cell phone that we can. So make sure that if you use your cell phone for to access the EHR or access any other kind of electronic system, or you use it, or you happen to have some patient information stored on it, make sure that it is cleaned and cleared properly before you return it and get a new cell phone. Same thing for fax machines, printers, any of those scanners, any of those devices that we use frequently in our business have and store patient information on them. And so it's important to make sure the hard drives from those are cleaned properly before they're returned, if they've been leased or if they're disposed of and there are new ones put in this place. Another one is clean desk policy. So make sure that you clean off your desk, and then before you leave, or things are put up so that no patient records sitting out can be viewed by other people. Prior to fax or email, make sure you verify your address and recipient. That's a frequent issue when you have a misdirected fax or misdirected email. It happens, it happens frequently enough to cause trouble for people. There's some other ones on here that I think are really helpful. One of the things that is required by HIPAA, and also something that the HHS and OCR really look for, and that is to make sure that your technology has encryption in place if it stores patient information. If it's transmitting patient information, like for instance, through a text message or an email, make sure that also uses an encrypted process. In addition to that, they want to see auditing of any kind of activity. So those are information system audits that are performed in order to show who accesses the information and when it's accessed and what's done with it. And then finally, a regular backup of all of your records. I have telehealth records there, but I think that relates to just anything. Make sure you execute a BAA, which we talked about earlier. Identify if you're using telehealth, identify telehealth and those privacy practices. And then make sure you train your staff properly. So as a recap, because as an employee, the employees all need to understand they have some basic responsibilities. Those are, they have to, and when they're collecting, using, or disclosing PHI, make sure that they understand that they're doing that for legitimate job function and that it's the minimum amount needed, that they're accessing information only for authorized purposes. And then finally, which we'll talk about at the end of this, they need to report promptly suspected privacy violations or impermissible uses, disclosures, or breaches, and then also comply with all of the privacy laws. Okay, so that's the end of the section on privacy. And okay, so security law was enacted in 2003, and then in 2013, HITECH amended HIPAA to make a business associate required to comply with the security rules as well. Prior to that time, the business associates did not have to comply with the security rule except through contract with a covered entity. But now they are directly liable under HIPAA for failure to comply with the security rule. So security, the rule requires that both covered entities and a business associate ensure the confidentiality, the integrity, and the availability of the electronic protected health information. So really what that means is that you have procedures in place, technical procedures, physical procedures, and you also have policies that require that the information, the electronic information, is accessed only by authorized people or processes, other for instance, other software systems that might want to access your EHR. Integrity. So you need to make sure you have in place processes to prevent alteration or destruction of the patient information. That is, so for example, you need to make sure that you have technical processes in place to protect it against ransomware, which can go in and alter and destroy patient information. And then availability, the last one, is to make sure that the patient information can be accessed when it's needed. And that's something that also is impacted by ransomware, other types of malware that may bring your system to a complete halt. Okay, so there's some basic elements of security rule, and these are all things that OCR tends to look at. And that is, the first one is whether or not you conducted a comprehensive enterprise-wide security risk assessment. So what OCR looks at is, have you included all of your locations, all of your devices, all of your people? Have you thought about what the potential threats, vulnerabilities might be, and how those affect your patient information? They want you to develop policy and procedures specifically around security, and then also to train the workforce. And one of the things they expect to see too is that when you train the workforce, you do that. You don't do it just once a year, but you do have periodic training during the year that relates to the patient information security. Like for instance, phishing emails are a big threat now, so they would expect to see, some periodic training regarding that. They want you to make sure that you have a process for logging security incidents, not just a breach, but any kind of security incidents that might actually impact the patient information and how you've responded to that. They'd like to see that you have a data backup plan, disaster recovery plan, and an emergency mode of operation plan. Those are all things that have become more important over the past 5 years, because when there is a ransomware or other type of incident that locks down your system, if you have a backup that can be restored, then that does significantly improve your ability to get back up and moving and have your records available. And the last thing is that you might have policies and procedures in place, but they expect to see that those have been implemented across the board. Okay, so as an employee, there are different things that you can do to help maintain PHI, and that's the first one is to make sure that your organization provides security awareness training. You participate in that, and do that on a periodic basis as well. Desktop and network access. One of the rules requires that you have automatic log off, and so that you need to make sure that your desktop is set to automatically log out a period of time, and that it's that the screen is not in a public-facing area, that is protected. Building access. It's important to make sure that the building access is protected and secure, that pass cards are not shared, and if they're lost, then they're replaced, and the supervisors are notified appropriately. That you have ways to monitor visitors and maintenance workers who come in and out of the building. With remote access, lately there have been more breaches that are in this area, and it's really primarily because we've had more teleworking involved. But if you have to access your desktop remotely, then the best thing to do is to make sure that you do that through a secure access point such as VPN, and that you also don't allow any unauthorized person to use that VPN portal. The other thing is, a lot of the remote access protocols have been, some of them are out of date, so it's important to make sure that your systems have upgraded appropriately and have to have the most current version of their software running. Okay, so some other areas are, we talked about repurposing information. So if you have anything that's been used to download or save patient information, like a hard drive or a flash drive, any kind of portable storage device, before you repurpose that or dispose of it, you need to make sure that it is properly cleared of all patient information. And then do not download any kind of PHI on any unencrypted device. That just leads to trouble. We've had had more breaches over the course of time from failure to encrypt information. So that's important to make sure that's in place. If you have staff that frequently transfer information onto USB drives or to a DVD, it's important to do two things. One, to make sure that you use a USB drive or a DVD that's been cleared and has been tested to make sure it does not have any sort of malware on it to begin with, or virus. And then also to make sure that when the information is put on that USB or DVD that it is encrypted. Okay, so password security. So your hospital or practice should have a password security policy in place, and it requires that you're assigned a username and password that's unique, and that you don't share it with anyone. So the general rule of thumb is to make sure that the password is something that's not easily guessed. That you use a combination of numbers and characters, and your policy for your organization will likely have a certain number of characters you have to, or letters you have to use. So in general, it's not a good idea to use information that's publicly known that someone could find on your Facebook page or Instagram or somewhere about you. So you can use something that's unique, like maybe if you have a favorite song or a Bible verse or a phrase from a book, something like that you have just several of those that you might be able to rotate and use. Those are always really, really good because those are hard to guess. So when I was growing up, my favorite book was Where the Wild Things Are. So one of mine, and it's a long one, so it doesn't have to be this long, but one of my suggestions is use a phrase from a book that was that you like. So and mine was and Max said, "Let the wild rumpus start." Okay, so network and device security. As part of the HIPAA compliance program, security program, you have to make sure that your network and security device safeguards are appropriate based on the rule. So there are several different suggestions. I guess from a physical standpoint, you don't want to leave the laptop or your mobile device in an unattended place if it's something that can access your EHR or other net systems that may have patient information, or if you have patient information stored on it. So for instance, if you had a patient that may have texted you. Do not bypass or circumvent any sort of configurations. Sometimes the encryption programs on the cell phones can slow things down, but it's important to keep that in place. On your laptop, it's important not to download any kind of app. If you have a laptop that accesses the network, that is, it's important not to download unessential applications without authorization. And then also make sure the antivirus is up and running, and the firewalls are up to date, and that you have backup procedures in place. It's also important whenever you're using smartphones or tablets that you use things that have been approved by your organization, and make sure that your employees or your staff has if you have a BYOD, bring your own device policy, make sure that people do follow that, and that the device has been I guess reviewed by your IT vendor or your IT staff and has been approved. And we talked about, make sure you don't dispose of your mobile device without clearing it. Make sure that your mobile device is protected and locked and has a wiping feature. Okay. These are some other examples of things you can do to help protect PHI by, when you have to remove it from the office. So we're going to move on. I'm going to move through these a little faster. Remote access to PHI. So we're going to talk a little bit, and later on I have a couple of slides about teleworking. But the general rule of thumb is when you have to access remotely access the patient information through the EHR or through other types of systems to your network, just make sure that you follow the same sort of protocol that you do while you're in the office. And also don't make sure that you're not sharing that with other people, either intentionally or inadvertently. So if you're in a hotel and you're trying to do some work, just make sure that your screen is not visible to other people, and that you don't leave your laptop open. Okay, internet and email security. So it's important not to send any kind of patient information over an open network. That's when it's not secured. Make sure that make sure that any kind of email is encrypted. Don't open suspicious emails or other links that are in an email. And be sure not to download any programs from public internet sites. Those are frequently loaded with viruses. Okay, these are some examples of phishing communications. And this we get these all the time. We're getting more of them now. Unfortunately, during all this COVID stuff, there was someone who was impersonating an OCR staff member who was contacting people by email and also by phone and trying to get information. So be conscious of who's sending the email. If it's something that's unexpected, best thing to do is not respond to that email, but instead try to contact the organization separately and independently from that. Yeah, and this is an example of a ransomware attack, which I know everyone's heard of so much now, but there are multiple different types of ransomware, and so they're just they generally have put up a notice that announces themselves and lets you know that you can't access your records until you pay the ransom. Okay, so we're going to talk a little bit about telehealth. Telehealth has gotten to be, it's now more prominently used, and it's been I think a really great thing during the time period. So in order to make sure that you are using telehealth appropriately, there are some things you can do. Right now, there's a telehealth enforcement discretion in place, but that does not mean that you don't have to comply with telehealth with the HIPAA rules that relate to telehealth. So technology should be used that meets privacy and security requirements, and so there's some minimum things that OCR likes to see, and those are encryption. Talked about that earlier. Make sure that the telehealth product provides encryption of the communications. Auditing. Make sure that they also they have the ability to audit the access, anyone's attempt to access information, use it. That they also do a regular backup of their records so that you would have access to that information should you need it. You should execute a BAA with any vendor that's providing telehealth services to you. And then again, if you don't have telehealth identified in notes of privacy practices, we do recommend that you update your privacy practices to identify the fact that you offer services through telehealth and information might be disclosed or transmitted to that service. And then one of the other things that's really very important is to make sure that you update your security risk assessment to include the telehealth services. Make sure that your staff knows how to use the telehealth compliantly and in compliance with your internal privacy and security policies. OCR does also recommend that suggest that you can get assurances from the telehealth vendors that you've contracted with that the telehealth technology is HIPAA compliant and that you should maintain a copy of that documentation. So many of these companies do have that information available on their websites, and so you can download it, keep a copy of it with the contract. So it's very important to have that in place. To the extent you can, some of the groups don't negotiate their contracts, but to the extent you can negotiate a contract, it's helpful to have a specific indemnification provision in the services agreement in the event that there's a HIPAA breach or a violation of law by the telehealth vendor. And then another thing is to make sure that the telehealth product can correctly integrate with your EHR. So you want to make sure that the record of the telehealth visit flows over into the EHR and can be maintained with the patient's record and is available. I guess one of the last ones is to make sure that you do also make sure your IT department reviews the HIPAA implementation and configuration specifications for the telehealth service. because they frequently have specific ways that they want you to have the service configured and used to make sure that it does comply with HIPAA. Okay, so if you're using telehealth, if you're using like your personal phone or personal tablet to provide the telehealth services, some of the things that we recommend doing is that you disable Bluetooth. And that is because Bluetooth opens the door for someone to come in and see what's going on your own device. That you also disable any kind of automatic functions that save photos or videos to your phone or your tablet. So some of the telehealth vendors, their apps have, are built so that the video or the photos of the patient and the whole session is never downloaded onto your phone. It doesn't enter your phone at all or your device, but it goes directly to your EHR. But others don't work that way. So if you're using one that doesn't have that type of application, the best thing to do is to make sure that any sort of photo saving apps or functions are disabled. Same thing with regard to social media. If you have your phone set up to automatically post something to social media, make sure that that's disabled. The last thing, which is also important, is to before you begin a telehealth session, is to make sure you disable or turn off your automatic backup to iCloud or other cloud services that might back up that are not related to your EHR, that might back up your phone or your tablet. And as a general matter, anytime you use a smartphone or a tablet or a laptop, you should make sure that it's password protected. OCR recommends double factor authentication or biometric authentication. Make sure that you permit or have it set up so that it permits automatic wiping remotely if it's stolen, and then and also automatic wiping of all the information after a certain number of unsuccessful attempts. Okay, so we'll talk about teleworking for a few minutes. We've all had to remotely. That's what I'm doing right now. We're still not in the office, but so whenever you have to work remotely, there are certain things that we need to make sure we have in place to protect the patient's information. So during this time period, while there's some enforcement discretion and waivers that relate to other areas of HIPAA, there is nothing that relates to telework. So when you're working remotely and you're accessing the patient information from your home or wherever you might be, it's very important to make sure that you remain HIPAA compliant. So treat the information the same way, and treat your access protocols the same way you would as if you were in a clinical setting. And if there's a HIPAA breach, it has to be reported. So just it's important to make sure that you just follow the same rules, same policies that you would if you were in the office. Make sure you protect your screens from other people. Don't sit in the kitchen and do the work if you can, and have kids, everybody running around you. Make sure you keep the equipment physically secure as much as you can. If it's a laptop, at night, try to put it up someplace where it's protected. Try not to share your equipment or the network access to your, certainly not the network access to your office or the hospital with your family or your friends. Protect your passwords. Do the same sort of things that you normally do just to protect all those types of things and maintain the virus. Protect the home. It's important if you're using your home Wi-Fi network, that you also make sure that your home Wi-Fi network is secure, that it has a password on it and it's not open to the public, and that you try to keep that protected as much as possible. Okay, we talked a little bit about HIPAA compliant smartphone and tablet use already, so we'll probably move on through this. Okay, so teleconferencing, there's been you know, with teleworking, we have to do teleconferences as well. And all of you, I know, have heard about the issues Zoom has had with people, you know, initially when that was being opened up and being able to be used, there was, you know, called Zoom bombing, where unauthorized people were entering the conversation and being present there and listening to it. So it's really important that you follow the protocol that's and the security safeguards that the government has recommended. So the Cybersecurity and Infrastructure Security Agency is an agency that was formed around 2015, and they put out a lot of educational pieces. So they have a whole, I've listed here a section of different types of things that they recommend that you do with regard to video teleconferencing, to make sure that you're using a secure system that has end-to-end encryption and does not allow access, the other unintentional access or unauthorized access to the patient's information. Okay, so we're going to talk about the emergency waivers and enforcement discretion that are in place now. So the administration issued a waiver, which is very limited in scope. It really only covers hospitals, and it's only for 72 hours after the hospitals implemented their disaster recovery plan. So it's limited, very limited waiver. It doesn't last long at all. The enforcement discretion is a little different. So under the enforcement rule, OCR has the ability to waive enforcement for actions that are not willful. So if you breached HIPAA because you were, you know, what they call, you know, a reasonable breach or a reasonable violation, then, and it's not a willful act. In those cases, OCR has the ability to waive their enforcement discretion. Now, if it's a willful violation of HIPAA, there is no enforcement discretion. They're required to enforce the rule. Now, for any of these, neither the waiver nor the enforcement discretion suspend the privacy and security rules. You're still required to give breach notification, and the enforcement discretion only lasts during the emergency period. Now, we don't know how long it's going to last because, you know, who knows how long this is going to go on, but it will, once the emergency period has been removed by the Department of Health and Human Services, then you have to go back to, you know, we go back to the time to the period of time where there might be enforcement. So under this too, though, if you say, for example, if the emergency is lifted in the month and you discover in October that a breach may have occurred in June, you still have to give notice of the breach. But if it falls in one of the areas that's covered by the enforcement discretion, then the government, unless it's willful, would not enforce the violation. So business continuity and disaster recovery plans are getting more attention now too. Those are plans that have to be in place and are required by the security rule. Okay, so we'll talk about breach. So a breach is an acquisition, use, access, use, or disclosure that's not permitted by the privacy rule, and one that compromises the security and privacy of the PHI. So not every unauthorized access is going to be a breach. So if there is a breach, if there is an unauthorized access, use, or disclosure, or a security incident, what you're required to do is go through what's called a breach risk assessment. And the organization has to assess the risk and determine if there's been a more than a low risk to PHI, in which case a breach must be reported. So every employee is required to report every suspected instance. And the reason that is important is, for a number of reasons, because the organization needs to be able to to jump on this immediately and determine what's happened and try to remediate what they can as fast as possible. The other reason is under the OCR's enforcement rules, if you correct a violation within 30 days of its discovery, then there is no enforcement. So it's important to act as fast as possible. Another thing that's important to let employees know, and staff and other people too, is that there is no retaliation for reporting a suspected instance of impermissible access or use or security incident. Okay, so all organizations need to take seriously the responsibility to protect the PHI, and in doing that, it's important to make sure that the organization has appropriate sanction policies in place. So what's recommended is generally that you notify your employees that they can be disciplined for failing to report a violation, but also for committing a violation. And those the discipline can range anything from a verbal and written warning all the way up to fines or suspension and termination. The employees and other people need to also understand that there is individual liability, criminal liability for violating HIPAA if it's willful. So we talked about a breach. Breach is determined based on 4 factors, really. So what is the nature and extent of the PHI involved, the type of the unauthorized person that uses or discloses PHI, was PHI acquired or viewed, and to what extent did you mitigate the risk? So in that regard, it's important to know whether or not the information was encrypted. So encryption is somewhat of a safe harbor. It used to be more of a safe harbor than it is now, but if the information is encrypted, then it is determined not to be a breach unless the encryption was bypassed by someone who hacked into the system and compromised credentials. So if the information was accessed at a level where it's no longer encrypted because the credentials of an employee or a staff member were compromised, then the encryption safe harbor would not apply. So covered entities and business associates have breach obligations. So the covered entity is required to notify individuals and HHS within a certain number of days. If it's more than 500 individuals, then both OCR and the individuals have to be notified within no more than 60 days. And OCR's position is the 60th day is really the very outer limit. What they expect to see is that you notify someone earlier on, and they look at the circumstances generally. So if it's a type of breach or incident that has really resulted in the release of very damaging information, then they expect to see notice earlier on than later. For breaches that are less than 500 individuals, they're required to report that annually, which is another one of the reasons for, which we talked about earlier, having a log of all security incidents and unauthorized access. So if a breach does happen, it's important to notify the privacy and security officer as soon as possible. If it's a technical breach, get the IT staff involved immediately. Make sure that the employees that identified it don't take any action independently of the privacy and security officer or the IT staff. Another thing is to make sure that whoever discovers it keeps that confidential. There's no provision for reporting for that individual to speak directly with the patient or any media regarding this. It's important to make sure that you have a notice posted it can be similar to what we have here, that notifies all staff members and employees of who they can report a breach to or a suspected incident. Okay, so the key takeaways really from all of this is that HIPAA compliance is really everyone's responsibility. That it involves everyone in the organization from top down. That you need to make sure that you stick to your job, don't snoop in the records, don't share records, and keep PHI to use minimum necessary. Make sure that all staff understands that there are sanctions that apply to violations of HIPAA policies, and if you for anyone, if there's been a violation or any sort of a suspected incident, If you're not sure, you need to report it. If you think it's been, too late, you need to report it anyway. So just make sure all these things are reported promptly and timely. And then also make sure that your staff does understand there's no retaliation. That's important. There has been an increase in complaints filed and investigated that are based on claims of retaliation. All right, so if you have any questions, I'm more than happy to answer some questions, and then we can take a break.
Awesome. Hey, Beth, this is Chelsea. So it looks like
Hey.
we had three questions in the chat box. The first is, it was during when you were on slide 32, the titled persons involved in a patient's care. The question was, can you detail the difference between general POA versus healthcare POA?
What do you mean by POA, I guess?
That's a good question. That was Laura Brown. Laura, let me unmute you and see
if I can find that.
It's power of attorney.
Okay. Sorry, there you go. I should know that. But, okay. So a healthcare power of attorney is one that's generally in the healthcare directive. So if the patient has a healthcare directive, that they will have someone in there that they designated as the person who can make their decisions. A general power of attorney is one that is sometimes provided to someone who's I guess a good example would be an elderly person who has given all of their care, financial everything over to a family member, and so that would be a general power of attorney, which would also typically include healthcare decision making as well. Does that help?
Do generals cover healthcare if they don't specifically mention healthcare? Is a question. I see that the follow-up question from Laura.
If they don't specifically cover healthcare, but the general power of attorney does give the caregiver power to make all decisions for the patient, then yes, that would generally cover any healthcare decisions as well. Those are really typically state law decision questions, not so much HIPAA though. So it's important to make sure that you check with your attorney regarding what the law might be in Washington.
Great. She said thank you in the chat box.
Okay.
Another question, the last question, it looks like it was on page 41. And do we have permission to use a screenshot of your presentation for training in our facility? Oh,
yes,
that wasn't relative to the presentation. Okay, perfect.
No, you can use this.
Perfect. Thank you. All right. I think we're good for a break.
Yeah, let's take a break.
Okay, we'll meet back here at 2:30.
Okay, sounds good.
Thank you.
Thank you.
All right, it's 2:30. Are we ready to get started?
Think so. Is everybody here?
I think so. It looks like we had a couple, I hope so. It looks like we had a couple of questions in the chat box while we were away.
Okay.
Are you okay with answering a couple of questions real quick?
Sure. Okay.
The first is, if the patient wants copies of records for him or herself, or they ask that record be sent to a healthcare provider, we do not have to get a signed authorization, correct?
That's right. That's right. You do not. In fact, OCR has said that it's an impediment to require them to sign an authorization if they've requested a copy of the record.
Perfect. Thank you. And then the second question is, if the patient expires and a family member or a power of attorney requests a copy of the record, do they have to provide a copy of the death certificate?
Okay. So we recommend that you get a copy of the death certificate and a copy of the executor, the document that identifies the person as being the executor of the estate, or that they're a family member, a relative. So that's what we recommend doing. I think you can use your discretion in getting identifying documentation, but that's our recommendation usually.
Perfect, thank you.
Okay. So are you guys ready to dive into part 2, substance use disorder patient records? This has really had a wild ride the last couple of years. So this law was originally enacted in the 1980s, and there was no activity at all on it for a long time. So there are really 3 areas that govern the confidentiality of patient laws that are relevant to you guys. That's HIPAA. The state of Washington has mental health privacy law as well, and then also the Part 2 law, which is the confidentiality of substance use disorder patient records, and that's in 42 CFR Part 2. That's why it's called Part 2. So generally under HIPAA, HIPAA we talked about earlier, it governs the privacy and security of patient information, has a breach notification rule, and it only applies to covered entities. So Part 2 is a little different in that regard, because Part 2 covers all healthcare providers that hold themselves out as providing substance use disorder information. So those may not necessarily be a covered entity under HIPAA, because it may be someone who only sets private pay and doesn't bill electronically to an insurance company or handle insurance at all. So, I was wrong. 1975. Forgot about that. So the regulations that relate to the confidentiality of substance use disorder and patient records arose from the Public Health Service Act, which was enacted in the 70s. And it covers a lot of different areas, but that section required the implementation of regulations that address the confidentiality of substance use disorder records. So it happened in 1975 and 87. That was the first amendment, and then nothing else happened until 95. There was another little small amendment, and then they issued some pretty substantial proposed rulemaking. So the final rule was adopted last January, well, more than that, so 18 months ago. And then last summer, they proposed some additional changes to the rule. And then lo and behold, during all this craziness, the CARES Act amended the Public Health Service Act to require amendment of the regulations that really conform it in large part to certain sections of HIPAA. So it's had a lot of activity over the past 2 years and very little for a long time. So Part 2, as we discussed earlier, Part 2 regulates different people, federally assisted programs that hold themselves out as providing diagnosis, treatment, or referral for a substance use disorder. So a federally assisted program is anyone that receives any money from the federal government really in any way. It doesn't have to necessarily be through an insurance, through Medicare or Medicaid, but it could also be through a grant or some other kind of federal assistance. It also regulates an organization, people that are considered to be qualified service organizations, and those are similar to business associates, but those are service providers that provide services to the Part 2 program that may access or use or have to disclose the Part 2 information. So the next one is a lawful holder. So lawful holder is a definition that includes an individual entity who's received information. So that may not necessarily be another Part 2 provider. It could also be another healthcare provider that's received it through authorization or other types of consent. So the lawful holder is anyone who's actually obtained that information and has it rightfully and lawfully and can use it as permitted under the regulation. So throughout these slides, what I'm going to try to do is put up, if there's a change that's happened either in the final rule, the proposed rule, or the CARES Act, have that on the slide. You can kind of see what the differences are that are happening. So currently, under Part 2, anyone who violates it is subject to criminal liability. And so there's a small fine, and if it's a particularly egregious accident, it would be, you could have some imprisonment. That's all enforced by the Department of Justice. So as we talked about under HIPAA, HIPAA is enforced through the Office of Civil Rights. The Part 2 right now is enforced through the Department of Justice. So the CARES Act, which was enacted in March, does make some changes. So it eliminates criminal liability completely. It changes the liability instead to civil money penalties, which aligns with what the liability is under HIPAA. It'll be enforced by the Office of Civil Rights, which is very similar to HIPAA as well. And it adds to this the requirement that you do not discriminate against in either access to care, employment, housing, based on a substance use disorder diagnosis or treatment. So those are really significant changes. So Part 2 provider, federally assisted means that it's an organization that's licensed and registered with the U.S. Department. So if you have to have a DEA registration, then that makes you a Part 2, potentially a Part 2 provider that fits the requirement of federally assisted. Federal payer contract, of course, that means if you have Medicare, CHIP, or one of those other federal government programs. If you're a tax-exempt program, or get tax deductions based on your substance use disorder program, or if you have services that are directly contracted with the U.S. government. And then the other part of that is that the organization has to hold itself out, or the provider has to hold itself out as providing and actually provides substance use diagnosis, treatment, or referral for treatment. So that means that you're an individual or entity that's not necessarily just a general hospital or general medical facility, but if you have a component within that facility, in that hospital, that does specifically provide the service, then that would make you a Part 2 provider through a specifically identified unit. Any kind of medical professional whose primary purpose is substance use diagnosis, treatment, or referral. And then any kind of activity that would lead someone to reasonably conclude that you are. And that's usually through, I guess what they typically look at is, what type of advertising and marketing do you have? What sort of things do you tell the public? Do you regarding your treatment or providing services for a substance use diagnosis, substance use disorder treatment. So one of the things that I do make sure that is excluded is ER physicians. So ER physicians don't really have a choice. So a patient comes in, they're required to treat them under EMTALA. So if an ER physician treats someone that has and refers them to the ICU or refers them to somewhere else in the hospital or to some other person for substance use disorder, that does not make them a Part 2 provider. Okay, so a qualified service organization, again, is similar to a business associate. They are someone that provides a Part 2 program services to a Part 2 program, like data processing, the medical records, technology, billing, legal, population health management, some consulting services. Maybe someone who's not a healthcare provider, but they may provide some other types of patient assistance services. So for all of those types of organizations, they're required to have a qualified service organization agreement, which is similar to a business associate agreement. And typically what people do is they'll just include a paragraph in the business associate agreement that addresses a qualified service organization. And that's really the easiest way to handle that, and just make sure you just combine the two and have it there in place. And that will be particularly much easier now, after the regulations are in place following the CARES Act, because the HIPAA and Part 2 will align very closely. Falls under Part 2 information, just like not everything falls under HIPAA regulation. So the records under Part 2 that are currently considered to be protected is information, whether it's recorded or not, that's received or required by the Part 2 program. So that means that if someone gives, if you have a phone call regarding a patient, the information that's transmitted in that phone call currently is part of the Part 2 information. Now that's being changed that's been changed in the 2019 proposed rule. So it's also information that identifies the patients with a diagnosis for substance use disorder, referral for treatment, or actual treatment for that. It includes their name, address, social security number, any kind of identifying information. And it includes the name and identification of the treatment facility. So that alone, combined with the name of the patient, is considered to be substance use disorder information. And the programs can, in order to try to, protect the information when it's transmitted to someone else, you can assign an anonymous number to the patient, as long as that number is protected and maintained in a secure environment within the program and is not released to anyone else. So the typical rule of thumb is to make sure that number is in an encrypted form, so that it can't be accessed or used when it's stored. It can't be accessed or used by anyone outside the program who doesn't have the appropriate credentials. Under the 2019 proposed rule, they're making a change with regard to verbal communications. So verbal communications are no longer considered to be Part 2. So if you're having a conversation with a primary care provider, and you're a Part 2 provider, then that conversation now will no longer be considered to be Part 2 information. So that opens it up a little freely and helps facilitate care and care coordination between providers. Treatment records are also that are created by non-Part 2 based on a patient encounter are not considered to be Part 2 information. And one of the things that they do recommend is that you do segregate the Part 2 records. So the Part 2 records can be segregated from the non-Part 2 records and kept in a different, kept in a physically or logically, technically, logically separated location, so that they are protected and can still be maintained within the same patient record. Okay, so the prohibited disclosures are basically the same. Still, you may not disclose information that identifies a person as having had or been diagnosed with or referred for substance use disorder treatment without their consent. There are specific forms for that. You can't even acknowledge the person is a patient at a particular program or a facility. And that's particularly true with regard to law enforcement. And you may not disclose to a contractor any information regarding a Part 2 patient unless you have in place a QSO agreement or a consent. And this is very similar to HIPAA. But again, note that a qualified service organization is not the same as a HIPAA business associate. So if you're dealing with a Part 2 provider who is not a HIPAA covered entity, you still have to have a separate qualified service organization agreement in place with any vendors. Okay, law enforcement. So one of the main reasons that Part 2 was put into place was to help open the way for people to seek care and seek treatment without the fear of being thrown in jail. So what they've done is so the rule does have very strict requirements around what you can and cannot do when disclosing information to law enforcement. So obviously you cannot disclose it without a valid court order, and that's not me for someone else. It has to be signed by a judge. It has a certain way. It has to be in a certain form as well. You may not acknowledge an individual as a current or a former patient. So if law enforcement calls on you and has a question concerning an individual, you can't make any acknowledgement one way or the other regarding that person. You cannot assist in search or provide any information regarding a person's presence or absence from the program. So if you have a resident who's maybe missing, you can't notify you can notify people who need to notify the person in order to help protect them, but you cannot allow the law enforcement to know whether or not that person is present or not at your facility. So the hot pursuit exception really means that you can help them if law enforcement is in what's considered to be a hot pursuit. If they are looking for someone that has committed a crime, then you can help locate the individual, but you cannot identify the patient. That one's a little tricky. You're not required to forcibly resist entry, so you can obviously allow the officers into your facility, but you can't assist them. The other thing is, to go back up here to the person being present or absent. So if there is an imminent threat to the health or safety due to a crime that's occurred on your at your program or on your premises, then you can notify law enforcement that has occurred. Okay. There are some permitted disclosures with consent that fall under the current 2018 final rule, and then also are included in the 2019. So with consent of the patient, you can disclose information to clinical professional support services, your patient safety activities. You can perform your healthcare operation services with patient's consent using their information. And that's different before, because prior to the 2018 final rule, you could not use any of this information for healthcare operations. You can use it to help train students and other healthcare professionals, for your accreditation, credentialing, licensing, underwriting, any kind of insurance activities. If you have third-party liability coverage, so if you have a claim, and you can use that information to help support your insurance. So that's helped there to identify the claim. If you need to do any kind of response to government actions related to fraud and waste and abuse, that information can be disclosed with the patient's consent. And then also conduct any kind of medical review, internal peer reviews, or any sort of auditing functions. Business planning and development. So this is one area where it does come up and is very similar to HIPAA. So frequently, businesses are sold, and so when they're sold, you have to be able to sometimes access information. The buyer and the seller have to be able to share some of the patient information in order to conduct the transaction. So this is one of those areas that would fall under that. Business management and general administration activities as well. Customer services, so providing any kind of data analytics for that you might need. And then resolution of internal grievances, mergers and acquisitions we talked about before, determinations of eligibility or coverage, and claims adjudication, risk adjusting, and review of medical necessity. So in the 2018 final rule, these were all things that were just identified in what's called the preamble, that really long part before they put out the new regulations. And that's all. This was so helpful that the Department of Health and Human Services and SAMHSA decided that it was really important to actually make this list a part of the regulation itself. So the 2019 proposed rule makes this part of the regulation itself, and is I think probably very helpful. Okay, so the consent, if we talk about consent, kind of like the HIPAA authorization, the consent has certain specific requirements. Currently, right now, the consent requires that you include, obviously the patient's name, and then you have to have a consent that specifically identifies the persons who are authorized to disclose the information, and the types of information they'll be disclosed, and the names and the recipients of the information to whom it's being disclosed. The purpose of disclosure is it can be revoked. The expiration date, it has to be signed by the patient or the patient's surrogate or their personal representative, and have the date of signature. One of the things that we recommend having is also having a witness signature on there, so that you know that not only did the patient sign it, but someone was there and witnessed it occurring. That's not required by the rule, but it's just a good rule of thumb to have. The 2019 proposed rule really didn't change much, except that you don't have to have any specific identification of the recipient of the information. But it did, so under the current rule and also the 2019 proposed rule, you still have to issue a new consent every time you want to disclose information to a new person or new entity. So the CARES Act, instead, what it has done is, under the CARES Act, once these regulations are released, the substance use disorder record can be disclosed with consent after there's been one general consent signed. That's very similar to what's happened, what you do with an authorization. So you don't have to have a consent to disclosure signed every time you want to disclose the patient information, once these regulations are in place. Currently, you still have to have a unique consent at every disclosure, but to a new recipient. I hope that will be changed soon. Okay, so notice of free. So once you disclose it to someone and they've got the information, what can they do with it? Well, they're not authorized to disclose it again, except if they're a QSO. They're not authorized to disclose it again without consent from the patient. So you have to have, on the Part 2 records that are disclosed with consent, you must include this notice on there. There's a long and then a short one that can go on at the bottom. That's the phrase can go on electronic records. So that needs to be on all of the Part 2 records or Part 2 information that's being disclosed to another person. To a central repository or a drug, or a prescription drug monitoring program. All the states have these in place now, and they require that you do disclose information to them and maintain, and they have required reporting for all those to help address opioid abuse and other substance disorders. So the having the centralized repository, centralized registry does help prevent any kind of duplicate enrollment. So and also the duplication in prescriptions and any adverse events. So it's a really helpful new change in the rule. Okay, so there's also change that addresses medical emergencies, and this is really to make sure that the patients receive the appropriate kind of care. So in a natural disaster or another kind of emergency, that's a declared emergency that's and the Department of Health and Human Services will declare that. Then in that instance, the patient records can be disclosed without consent. So I guess, for instance, right now we're in a declared emergency, but it's not a natural disaster. So once hurricane season hits, it started 2 days ago, if we have a hurricane, then it's been the Department of Health and Human Services practice in the past to declare a national emergency or declare a state of emergency for that geographic area. And so for the treatment facilities that are located within that geographic area, they would be able to disclose substance use disorder information to other providers to help, continue care for the patients that may have been residents at their facility and had to move elsewhere because of the disaster. Okay, so for research purposes also, you can disclose information to Part 2 to a HIPAA covered entity or business associate. And it's for research purposes. It kind of overlaps. The common rule is the rule that governs the research of human subjects and how the information is handled, and that does have some overlap with HIPAA. So under Part 2, there, and we talked about that. We listed some of those earlier. There was that long list of permitted disclosures that can occur for audits and other kind of program evaluations. So Part 2 did have some changes that related to that allowed you to disclose information needed to conduct internal audits and evaluations, and also to respond to government audits. Okay, so the 2017 rule making did have a technical error in it. So I'm not sure if it's technical or not. But anyway, the phrase was that you could disclose information for the purpose of investigating an extremely serious crime that was allegedly committed by the patient. So what they did was they took out that part of it to make sure that it protects someone who's not been, who just has allegations raised against them. But it has to be a little more clear about the industry. Okay, so right now, under Part 2, there, undercover agents and informants can be placed within a Part 2 program, and that's been, there was some concern with the Department of Justice and law enforcement that the current policy is overly restricted, so that's been extended to be extended for a period of 12 months. So the courts can authorize that to be further extended and allow the continued placement of the undercover agent or informant within a program if needed. Okay, so the CARES Act, those were all of those were changes that were in the 2019 proposed proposed rule. So the CARES Act amendment has made a lot of changes, and the changes, they require that regulations be put into place by March 27th of next year. So during that time, the laws that currently stands will continue, and I really don't know what's going to happen with the 2019 proposed rule, because it was done as a way to try to ease Part 2 into more into closer alignment with HIPAA, but with the CARES Act, that's kind of been pushed aside. So I'm not sure if they're going to finalize the 2019 rule or not. Will be interesting to see. So the CARES Act does very clearly align the Part 2 rule with HIPAA. So you'll have just one consent for treatment, payment, and healthcare operations. You don't have to provide a consent for de-identification of data for public health purposes. You can't allow your vendor or service provider to de-identify the data for any other purposes, but you can have it de-identified for public health purposes. It allows requires you to notify it to update the notice of privacy practices, which is something you'd have to do. So they'll go through rulemaking, and once the rules are in place, then after 60 days after that, generally you'd have to have your notice of privacy practices updated. But that would be updated to include the patient's rights and how they can exercise their rights with regard to Part 2. It does reinforce the prohibition on the use of substance use disorder in a criminal context. The CARES Act also has the right to request a restriction on disclosure for services paid in full and for treatment, payment, and health operations, just like the HIPAA does. And then it also made an amendment that adds the right to non-discrimination, access to care, employment, housing, or social services. And this is new, and it is in line with the Department of Health and Human Services direction to really enforce discriminatory acts and access to care, and to really enforce and try to build up patient rights. It institutes civil money penalty, as we talked to before, that removes the criminal liability and puts in place instead a civil money penalty and liability that aligns with the HIPAA enforcement. It requires breach notification that tracks the same sort of that we expect will track the same sort of requirements as HIPAA. And all these changes, they're required to issue regulations by March 27th of next year. So that's really not much time. Okay, so do y'all have any questions? Hey, Chelsea, does anyone have any questions?
Oh, sorry about that. I thought I was still on mute. Okay. We actually just had one come through, and it says, I think I missed the TPO consent. Can you elaborate?
The TPO consent.
Yes.
So under the CARES Act change, or I guess so under the current rule now, any disclosure for treatment, payment, or healthcare operations has to have a consent, and it has to be there has to be a unique consent for each recipient to whom it's being disclosed, unless you have like a group. So the way that it will be changed is that with the 2019 proposed rule, you only have to have one consent for a type of disclosure. It could be a general consent. And then under the CARES Act change, it would be very similar to HIPAA's authorization now. So you just have one general consent that allows disclosures for treatment, payment, and healthcare operations.
Oh, we got a thanks in the chat box.
Okay. All right. Well,
Beth, I'm sorry.
yeah.
There's something out there. I guess I'm kind of with a previous question on the when consent for treatment, payment, and operations. So
Yeah.
what you're saying, with the CARES Act, there's one consent, right? But
That's right.
But is that what's being enacted right now, or is that not until 2021?
That's not until 2021.
Okay, all right. So these are proposed amendments.
Right. So right now, well, so the CARES Act amended the statute. And what happens then is that Department of Health and Human Services has to issue rules and go through the rulemaking process to have the regulations put into place.
Okay, all right.
They really don't have much time to do that, but they have to have those regulations available by March 2021.
Okay.
Yeah. So currently, you'll have to have a unique consent for each disclosure.
Thank you. That's very helpful.
Okay.
Beth, this is Chelsea. We have another question in the chat box.
Okay.
And it says, is information created by a mental health program that references SUD information protected by Part 2?
Okay. So if you're a mental health program and you have taken in a patient that was formerly a substance use disorder patient and you receive information from their treatment provider, then that information is still Part 2 information. And it has to, and so you have to protect that information in the same manner. Now that does not make you a substance use disorder provider, though.
All right, is there any other question? Okay, I'm not seeing any come through. Did we want to take a break, Beth?
Why don't we take a little break and then just 10 minutes, and then we can get started on 21st Century Cures Act, and then I think that because I think that'll flow better.
Sounds great. How about we meet back here at 3:20?
Okay.
Perfect. Thank you. All right. It is 3:20. Hope everyone had a nice little break.
Well, that's because we're going to need it. Oh gosh. Well, this is what I've been waiting for. I'm very excited about these new changes. So we're going to talk for the rest of the time about the 21st Century Cures Act and interoperability and information blocking. And this is I'm very excited about this rule. I think it's going to make a lot of good changes, and it's going to be a very positive thing for both for healthcare providers and for patients as well. So we'll talk a little bit about the Act, about interoperability itself, and then how that kind of flows into information blocking and helps facilitate that, as well as access to information. There's a lot of intersection in information blocking and HIPAA, so we'll talk a little bit about that. And then we'll also go over the enforcement and civil money penalties provisions. And at the and throughout this, particularly in the information blocking section, I have suggestions for things you can do to update policies and also address contracts with vendors that are hopefully helpful. Okay, so I'm gonna date myself a little bit. When and I'll tell you a little bit about myself. When I grew up in a really small town, my father was a family practitioner there, and this was so I met my husband in 1988, and I was in law school, which to my father was just like, you know, the den of devils, and no doctor likes a lawyer. And then my husband, who I met, was working in healthcare technology. And back then, doctors didn't like healthcare technology either. So he was unhappy with my choice of profession, and initially not so happy with my choice in a husband. But in the early 1990s, he was working with a company that had developed one of the first electronic health record systems for physician practices, and my husband was one of the first. I mean, my father was one of the first adopters of that. So he was. So it ended up being a really good thing. Worked out well for everybody. But back at that time, you know, there was not HIPAA wasn't even around. So 1996, HIPAA was adopted, and we still have paper records going around, and a lot of people still today do still have paper records, but we had nothing but paper records then. And eventually, you know, electronic health records were put into place. So then we had, in 2009, we had, you know, the ACA put in place HITECH, which the whole purpose of that was to help incentivize the adoption of electronic health record technology, and provided for meaningful use and the incentive payments that went along with that. And the whole idea really is to help facilitate the electronic submission of data, both between providers and for patients, and also for public health activities to help improve the health around the country, and yeah, for organizations like yours. So it was a great thing, but that was only part of the step. And the whole process is a long road to providing, you know, better access to patient records across the board. So so we now have the 21st Century Cures Act. So ONC's goal for that really is to give patients the ability to access their records at no additional cost, and to give providers some flexibility in choosing the type of health IT tools they want, and also being able to transfer records between systems without running into the barriers they do today. So the 21st Century Cures Act was adopted in December 2016, and it's taken a while to get to this point. There's been a lot of discussion about the different provisions and, you know, what's best for everyone. But in the end, they've come up with something I think is, you know, hopefully we feel it'll be helpful. The compliance dates have been pushed back because of the COVID situation. The compliance dates were pushed back initially 3 months, and for some of them pushed back further. So the first compliance date is January 2021, and then it goes through April of 2023. So Donald Rucker had a lot of things to say about this, but these were in, I think both of these quotes came from a HIMSS meeting, and he was talking about the fact that you can access, everyone wants to be able to access their health care on the phone. And he said that the APIs really, and they really have transformed the industry and made the smartphone one of the best tools that we have in other areas. We all can access our bank records on our smartphone. We can connect with our friends. We can do all kinds of things with our phone, but we don't have access to our complete health record. So one of the driving factors or driving functions of 21st Century Cures Act is to make sure that there are APIs in place that help transmit the information between the provider and the patient's own personal health record. So an API, I guess the best description I've been given is when you go into Amazon and you enter your credit card information, that process is an API facilitated by an application program. So anyway, he said the goal is to give patients electronic control of their medical care, their chart, and their information through modern software. They want to make sure it uses the patient's data for the patients to control as they desire, rather than purely controlled by providers and payers. Now that's a big change from where we are now, and it's going to take a lot of adjustment, I think, probably to get people there. As providers, everyone's concerned about, when you release the information to the patient and to this, through this device that the patient has identified to their personal health record. How do you do that, and what is your liability, and how can you protect yourself? So we'll talk about that through some of this discussion today. Okay, so there are 3 rules that regulate the there are 3 rules that regulate the regulations under the 21st Century Cures Act. There's a CMS as a final rule, and that one really regulates the payers like Medicaid and also healthcare providers. ONC has a final rule, and that's the Division of Health and Human Services that really monitors health IT, and so they regulate the certified health IT developers, the health information exchanges and networks, and also healthcare providers. And then the last rule is OIG. So the OIG, the Office of Inspector General, enforces is one of the enforcement arms of HHS. So HHS has 2 enforcement arms, the OIG and the OCR, which we talked about earlier. The OCR enforces HIPAA, and the OIG enforces all the other areas under HHS. So the OIG has proposed a civil money penalty provision under the CARES Act that is right now its proposed rule hasn't been finalized. So we don't really know how that's going to shake out, but it does handle the enforcement. It'll handle the enforcement of this rule. CMS also has some enforcement, and we'll talk about at the end of this. We have a little section on enforcement. So, all right. So first thing we'll talk about is interoperability. So the ONC right now has in place a certified electronic health record program. So you have an authorized body like I think Drummond is one, and then there's some other ones that test all the electronic health record technology to make sure that it fits the certification requirements set out under HITECH. And so that's going to change. And what they're going to do now instead is that, and by the way, the certification program's always been voluntary, but of course, for any physician or a hospital to get reimbursed for services and receive incentive payments, they're really required to use a certified technology. So while it says it's voluntary, that's probably not a real option for many health IT developers. So anyway, the CMS Promoting Interoperability Programs, which includes the former Meaningful Use Program, which is now MIPS, requires the physicians' hospitals to use a certified health information technology in order to access certain incentive payments and also to avoid any reductions in reimbursement. So the health IT developers are required to meet certain certification requirements under the 21st Century Cures Act. They're changing that those are being called conditions and maintenance of certification requirements, and they're also reducing the number of certification requirements that are required. They'll no longer have the testing bodies, and instead they have something called real-world testing. So there'll be companies that will offer services to test the health IT technology to make sure that it meets the certification requirements. And the developers have to make certain attestations every 6 months now. So initially it was just when they first had the product tested and certified, but now every 6 months they have to reaffirm their attestations, and those include things that they are not going to engage in information blocking. So that's really a big change in how they're going to regulate developers. They're giving them some freedom, but also holding them more accountable in the end, because right now the accountability really is, I think you're all aware of what happened with eClinicalWorks and Greenway, and they had some investigations and ended up settling claims with the government that their products were not certified. So now, instead of having to go through that process, instead health IT developers are being held more accountable, and the Office of Inspector General, the OIG, has the ability to enforce that through some pretty hefty sanctions. So it's there's a change in that, and there's 7 conditions of maintenance certification that the health IT product will have to follow. Uh-oh. Sorry, missed my, okay, so the first one, the first one is what we're going to talk about a good length after we finish this section. That's information blocking. So the health IT developers have to attest every 6 months that they will not take any action that constitutes health information blocking. This is something that's continuous. So there's a condition of certification and a maintenance certification. So for this one, there's no maintenance requirement. That's just a continual issue that they have to make sure that they comply with. Okay, so the one is they have to provide certain assurances. They have to assure that they will not engage in information blocking. They have to ensure that they're in full compliance with all the certification criteria. They have to make sure they don't take any action to interfere with anyone's ability to access and use the software. They have to disclose and attest if their health IT information stores any clinical information. And as part of that, they have to maintain all their documentation of this initial compliance and their every 6 months, their attestation, and then their annual testing. They have to keep that up to date for 10 years. Okay, so communication. So the health IT developer now also cannot restrict certain kind of communication. So a lot of the health IT developers don't want to allow you to use screenshots in training or other kinds of things, which sort of slows down your ability to train your staff on how to use the product. So they've made some changes in what kind of communications can be made. So you can't prohibit or restrict any communication regarding the usability of the product, its interoperability, or security. That means that you can't, you can publicly disclose information if you need to. What they really want to do is make sure that you are not, by contract, you're not prohibited from disclosing the information to regulatory authorities or to someone who might need to provide, have that information for to enforce the requirements here. There's no restriction about a user's experience or the business practices of the developers related to exchanging the electronic health information or the manner in which the user has used the health IT. So there are other ones there too. So you can't have restriction against disclosures that are required by law, and disclosures that result in adverse events or hazards or unsafe conditions, cybersecurity threats or incidents, information blocking, unlawful practices, and then also the failure of the developer to comply with the certification requirements. Okay, some of the permitted prohibitions and restrictions on communications really relate more to protecting the information protecting the IP rights of the product involved, and also the health IT developer's internal operations. So they can still include, a health IT developer can still include in its contracts with its internal employees or its contractors restrictions on what can be disclosed concerning the information. They can also prohibit restrictions on non-user facing health IT. Those might be like an interface, for instance, or other types of health IT that doesn't direct that healthcare provider as the user or a patient as the user doesn't interact with. The IP restrictions really have to be limited very closely only to what's necessary to protect the property of the intellectual property of the developer, and they can't restrict the fair use of a work. That's sort of a technical term, and I guess under intellectual property law. There are also some restrictions on use of screenshots and videos, but you can use a screenshot and a video for training purposes and for other things, but you can't change it or alter it in some way. And then obviously they want to allow the health IT developers to protect any kind of communications that relate to the product prior to it being tested and marketed. Okay, so the health IT developers, and I forgot to put the date in here. Health IT developers are all required to notify their customers starting this year that that any communication or contract agreement that violates this condition, the communication condition of certification, will not be enforced, and they're required to amend their contract to remove any kind of provision that would prohibit or violate this communication certification requirement. Kind of similar to when everyone had to update their BAAs in 2013. They have to do it as soon as possible. Okay, so the application programming interfaces, that's another. They have certain things that they have to also attest to. And those are, so they have certain certification criteria as well. They have to publish their technical documentation to make sure that the API can be used to communicate between systems, and there's no interference with that. They're limited in what kind of fees they can charge as well. It has to be very, reasonable and very limited, and it's highly regulated. And the whole idea is that it promotes an open and competitive marketplace. So, right now, because there's been so much proprietary technology, the ability, as you all know, the ability to change EHR systems or other kinds of technology sometimes is complicated, takes time, and is unnecessarily expensive at times. So they wanted to make sure that we don't run into that problem with the APIs, and those are being implemented and put into place. Okay, so real world testing. So the HIT developers have to participate in and successfully complete real world testing. They have to, in order to do that, they have to submit their plan to the ONC by a certain date, which is the latest December 15th. It has to be approved, and then they have to complete their testing by March the 15th, which is really not a long amount of time. Health IT companies, it's hard for them to especially the initial ramp up to this is going to probably be a little difficult, but the compliance deadline for them is pushed farther out. So for the whole process to be completed, I think it's 2023, but parts of it they have to comply with parts of it starting in January. Okay, so the attestations, the developer must attest to compliance all of the conditions and maintenance certification every 6 months, and they only have a 30-day window for that. So the first attestation time period will open on April 1st next year. And one thing to note for any health IT developer, when they make an attestation, that does subject them to False Claims Act liability because their systems are being used for reimbursement purposes. So even though they're not a healthcare provider, they are still subject to that law for if they make a false statement. Okay, so the next 3 slides really cover the updates and changes in the certification criteria. So right now, under high tech, there's a pretty long list of things that an EHR or a different type of module has to certify to being able to do. So what they've tried to do is to change those, remove the ones that are really redundant that people do anyway now because it's gotten to be a matter of course, put into place some new ones, and try to scale it down to make it easier and simpler for everyone to understand and comply with. So they're going to, with the drug formulary, smoking status, secure messaging, all these things, the top list, those are things that have really been in place for several years now and are pretty much common, something that happens commonplace. The CCDA through this rule is being replaced with a set of data called the US CDI, and we'll go through that in a minute, what that is. And then an API is being replaced, the API requirements being replaced with this new one. And then the data export, instead of having to export the data that's set out in that specific certification requirement, is going to be the full EHI export. So we'll talk a little bit about what those terms mean, US CDI and EHI. As the revised criteria, they're revising interoperability criteria to again replace the CCDA with the USDA criteria. Security tags regarding information being sent so that it's easy to trace it. And then they're going to align the electronic scribing and CQM requirements with what CMS has in place, which is very helpful. In addition to the new things that we're having in place is the electronic health information exports. That's really based around the definition of ePHI under HIPAA. They're going to include a privacy and security attestation requirement, which is something that is also new, and then have a standardized API for patient and patient population services. So these next 2 slides are they're actually from the ONC slides. So they kind of describe and set out the sections for the sections that specifically address these certification criteria and a little more information about those. Okay, so we'll talk about the timeline for the certification portion of it. The rule was adopted on May 1, 2020. It was supposed to be adopted in March, but they pushed it out because of COVID and to give people a little more time to address it. So then that pushes everything else a little bit farther. So the health IT developers have to begin, the 60 days after the date of publication. There are certain conditions of certification they have to go ahead and start complying with. And one of those is the restriction on communications and also information blocking. And it talks about all these, the timeline has all these other things out here. The first deadline for real world testing is December 2020. I think that's been extended for 3 more months because this came out before the COVID thing. So all these dates are pushed out a little bit farther, about 3 months. But in the end, the final part of it will be completed in 2023. Okay, so we talked a little bit about the ONC interoperability requirements. CMS also has some interoperability requirements, and these relate primarily around the ability of a patient to access their own payment information and payment enrollment, claims information. So what all Medicare Advantage plans, Medicaid, CHIP, QHIP, they're all required to have in place a patient access API that will allow the patient to access all of their information that the payer may have. They're also under CMS's rules, all hospitals, psychiatric hospitals, and critical access hospitals have to have their EHR has to have a function that allows them to send admission, discharge, and transfer event notifications to the patient's primary care physician and any other providers the patient might identify, like a skilled nursing facility or rehab facility. And this will be a condition of participation. So in order to continue to, to participate in the Medicaid contract, you'll have to have this, make sure that your EHR has this function in place. The providers also will have a provider directory, the payers will also have to have a provider directory API that allows the patients to access information regarding the provider network and some other information that the provider network may provide, the payers may provide regarding the providers. Has to have payer-to-payer data exchange. So all the Medicare Advantage organizations and Medicaid and CHIP and QIP have to be able to coordinate between themselves to exchange information, and between other payers to exchange the information, that the same type of information that the providers will have to be able to exchange, which is the US CDI data elements. And they also have to respond to patient requests to share this information. And that patient right will extend for 5 years after the patient's coverage ends. So that alone is a really huge, really big difference, and it's going to be it's going to require a lot of work on the payers' end to get these things into place. The last thing that CMS does is public reporting, and that's really, it's very similar to what's being done now through MIPS, but they'll continue to physician compare page in MIPS. Through MIPS will continue to identify the clinicians who do certain things, but they'll use the MIPS reporting to identify providers who do not attest that they'll prevent information blocking. So they'll have certain MIPS, there will be certain information on there. Can you guys hear me still?
Yes.
Okay.
Yes.
Sorry. Thank you. Sorry, my headphones made a weird noise, so I'm not sure if they're running out of juice. So anyway, so if you don't hear me, will somebody let me know, and then I'll just switch to, I'll take my headphones off. So anyway, where was I? Okay, public reporting. So in addition to the public reporting that's available on the Physician Compare right now, CMS will start including lists of physicians and clinicians who don't prevent information blocking, and they'll have certain questions that you have to answer in your MIPS attestation that address specifically information blocking. So if you don't answer those correctly, then you'll get on this list. Okay, so we're going to move on to information blocking, and the interoperability section is really all of that's supposed to help facilitate, access and use of information, both for everyone, really, to make it more freely accessible. And so that's where it flows into information blocking. So the information blocking is, this is the definition of the regulation. It's a practice or conduct where, except where it's required by law or covered by exception, is likely to interfere with the access, exchange, or use of electronic health information. And if it were conducted by, so if it's a practice performed by a health information technology developer or a health information network or exchange that is likely to interfere with, prevent, or materially discourage access, then that's information blocking. It's the conduct that by a provider that's unreasonable and likely to interfere with access or exchange or use PHI, then that is information blocking. Then they have a separate section that talks about the difference between the electronic health information, what has to be disclosed. We'll talk about that in a second. So there's their first thing. So information blocking is the regulations regulate healthcare providers, health IT developers, and then health information networks and exchanges. And it addresses only electronic health information. So there's a specific definition for that. It's very similar to HIPAA. And it occurs when the conduct is likely to interfere with access or exchange of electronic health information. We talked about this earlier, and that there's a difference between health, when a health IT or health information network engages in a healthcare provider. So healthcare providers that are regulated by 21st Century Cures Act are not the same as the healthcare provider definitions or HIPAA. There is a very specific list, and here it is. It's very long, but it is different from a healthcare provider that may be a HIPAA regulated provider. So, for example, a medical device company that bills Medicare or Medicaid for its devices is a HIPAA regulated healthcare provider, but they're not on this list. So they're not regulated by the 21st Century Cures Act. I mean, this pretty much covers the whole shebang, but it doesn't list dentists. There are some other groups that are not regulated by 21st Century Cures Act that are HIPAA regulated. So a health IT developer is any individual or entity other than a healthcare provider itself that self-develops their own health IT. So, for instance, like there may be a large hospital system that has an innovation department in their system, and they try to develop in-house some of their own health IT, and that would not fall under this definition. So it's an individual entity that develops or offers health information technology and engages in a practice that's the subject of an information blocking claim, or one or more of its health IT modules are certified that's recognized by the ONC. So this doesn't exclude, again, any health provider that's developing something for its internal use, and only applies to a health IT developer for the time during which it markets a certified health IT product. So if a health IT developer has gone out of business or is no longer providing a certified product, then it is not subject to this rule. Okay, health information exchange network or exchange is defined. They changed this from the proposed rule. So it's an individual or entity that determines, controls, or has discretion to administer any requirements that permits, enables, or requires use of any technology or services for access or exchange. And it only applies between if there's two or more than two unaffiliated individuals, and if it's for treatment, payment, or healthcare operations purposes. That last section was added in there because the way it was written originally, it could have included things like a clearinghouse that is intermediary that accepts information, changes it up and then sends it out again, or it could have included someone like an MSO or a DSO that helps facilitate the access and exchange of the information, but it's not really technically not a health information network. Okay, so an electronic health information is it's EPHI as it's defined by HIPAA, but it is EPHI that is maintained in a designated record set. So it does not necessarily include all information, but it could include some patient information. So the designated record set definitions or HIPAA is those are medical records and billing records about an individual, some enrollment, payment information, claims adjudication information, and then really any records that are used to make a decision about the patient or the individual. And that can include some payment information, but not necessarily. So this applies to this definition of EHI, though, applies to all information that's being disclosed between someone that's regulated by 21st Century Cures Act, even if they're not a covered entity. 24 months, though, so electronic health information is like basically, the full set of information. At some point in time, the patient makes a request for records, you have to be able to produce that whole, that all of that information, or if someone else does. But it has to be able to be completely exported. Right now the only requirement is that the electronic health record export the CCDA. So under this rule, the electronic health record will have to export the entire patient record at some point. So for the next 24 months, though, what they're doing is that they're requiring only that you export the US CDI. And so this is a list of the sort of the general categories of information. At the bottom of the slide, I have the website. So the US CDI is a little more expanded than CCDA. It has, includes allergies, treatment plan and assessment, care team members, clinical notes, goals, health concerns, immunizations, laboratory, medication, patient demographics, problems, procedures. I'm not sure what provenance is. Smoking status, unique identifiers for the patients if they have an implantable device like the pacemaker or something, and then vital signs. It does not include things like X-rays or other kind of digital images, but at some point all of that will have to be able to be exported through your electronic health record system. So the EHI does, though, exclude just, and USCDI as well, does exclude, just like HIPAA does, excludes from its requirement the psychotherapy notes that are maintained by the healthcare professionals, separately and segregated. So the USCDI requirements those will be in place for 24 months after the rule is effective, which is 60 days from the day it was the day that it was adopted, which was May the 1st. So June 30th, the USCDI standard has to be, you have to be able to export that. And so it'd be a good idea, to verify with your electronic health record system that they have this capability in place. Okay, so the ONC has provided several exceptions or things they've identified as not being information blocking, but they've also in the preamble included several examples of what they do consider to be information blocking. That's helpful. Then help because it's what they're trying to do is provide examples of what you can do, but you also, it's helpful to know what they consider things you absolutely cannot do. So the first one is the contract. So contract provisions cannot have terms in there that result in a restriction of information. So you can't have a BAA that's used as a way to help discriminate in access. So they have to. So really, what they're trying to say is just make sure that the contract terms that you have are non-discriminatory and are applied consistently across the board. So you can't have different BAA terms that permit access to some people, greater access to some groups of people, and reduced access to others. So that's going to require some review of existing BAs to make sure that you don't have anything in there that would result in a violation of this rule. Another example is in a lot of the health information technology contracts have provisions like this, and those are that if you are late on your payment, then they'll suspend access to the electronic health record system or the other health IT system, and so that's something that would be prohibited under this regulation as well. Another one is to limit or restrict interoperability. So we talked about earlier how the APIs the developers have to publicly disclose the information to enable its use, so that there's not, you don't have the problem with people trying to access the information. So under this one, you have to, all of the health IT developers have to publicly release their information that relates to the ability to access the information through the endpoints, to connect, for the APIs to connect to two different types of products, software products. You can't have any sort of activity that impedes innovation and advancements and access, exchange, or use of health IT enabled care delivery. So this really relates to if you have any patient-facing third-party applications, then you can't, another health IT developer or someone else can't refuse to license that because of some concern, unless it's a valid concern. So like if there is a valid concern that relates to security or privacy, then you can refuse to license that product or use it. But again, you have to make sure that you have all of these things are well documented, that you have policies and procedures in place that address them, that you apply consistently and non-discriminatorily and across the board, and that it is a true actual security risk concern. So rent seeking and opportunistic pricing practices. Those again, so if there is a, you have some of the health IT developers may have costs or prices in place that are uncertain about what they're related to. So that this really sort of does help level that out and reduce that, prevent that from happening. One of the things that they discussed too is in a termination of a contract with a health IT vendor, when the information has to be transferred over to the new product, you need to make sure that they're not allowed to charge you an inflated price for the transfer of information. It has to be something also that you agreed to in writing at the time you signed the contract. Okay, and the last one is a non-standard implementation practice. And this is where they refuse to implement some common technology standards and instead want to use something that's proprietary, and that prevents really the exchange of information between systems primarily. Okay, so there are 8 information blocking exceptions: preventing harm, privacy, security, and feasibility, HIT performance, content manner, fees, and licensing. So we'll go through each of those, and I also have some suggestions about things that you can do with regard to each of these. So preventing harm exception. So you can you're allowed to engage in information blocking or to refuse to release information if you think that it's necessary to prevent harm to a patient or another person, but you have to follow some conditions. So there has to be a reasonable belief the practice will substantially reduce a risk of harm, that the practice must be no broader than it's absolutely necessary. Excuse me. It has to you have to also be able to identify the type of risk, type of harm, and the implementation of the basis for the exception, and satisfy the condition concerning the patient's right to request and review an individualized determination of risk. So what you need to do really is develop a policy. Okay. Develop policy identifies the harms and risks based on the expertise of the actor, and provide a process for making determination and creating and maintaining the documentation, and the notice requestor with the right to request review and reversal determination. So in your notice of privacy practices, it's good to have, we have in our current ones right now, you have a statement in there to, to everyone basically, that you have the right to, if you, request access to records, you have the right to review the denial of that request. Same, and so it's a good idea to update those privacy practices to include something that notifies the patient that if they've been denied access and it's based on this exception, then they have a right to have that determination reviewed. So the types of risks that that can be the basis for this are really those that you as a healthcare provider in your professional judgment can make a decision concerning that. You just need to make sure that it is something that is reasonable, and it can rise from either data that's known or reasonably suspected of being misidentified or mismatched or corrupt, or that the data somehow otherwise might be an issue. If there's obviously if there's harm to the patient, harm to another person, or the life or safety of the other person, then that is another area that would be an exception under this. Okay, so the privacy exception is again, if the actor determines that release or disclosure of the information would endanger the privacy of it, then he can refuse to do that. So, or the healthcare provider can, or it could be another health developer. But so to satisfy the exception, you have to there's several subsections. You have to meet at least one of those, and all the conditions that apply to the subsection have to be relied on. So the first one is that there's unsatisfied legal preconditions to release the EHI. So for instance, if you have to have a consent or an authorization that's not in place, then that would be a reason for not disclosing the information, and you wouldn't be considered to have engaged in information blocking. The condition is that this has to be documented in formal written policies, or if you don't follow the policy, it has to be a case-by-case determination that's related specifically to that precondition. So I use as an example the Part 2 information disclosure without consent. So the other condition is that if you're withholding information because there is an inadequate consent or authorization, then you have to, as timely as possible, make your best efforts to get that consent and authorization in place. And you cannot encourage someone to withhold their authorization or consent because you don't want to disclose the information. So those are the conditions. So the certified health IT developer, obviously that's not covered by HIPAA. So if you have one that's not a business associate, an example would be a patient. A patient has identified their personal health record software as something that they want to have information sent to. So that certified health developer may restrict disclosure based on its published privacy policies. They don't have to have HIPAA privacy policies in place because they don't have a contract or relationship with the covered entity, but just the patient. But in order to say that health IT developer will not disclose information, they have to have policies in place that they publish, and those have to be relied on and followed. The policies also have to be in compliance with state and federal laws and specifically address the privacy risk. There is a model privacy notice that the ONC has drafted and recommends for these types of entities. So that's helpful. Now, the next one is denial of an individual's request for ePHI has to be consistent with the privacy rules. So if So if you deny it for it has to, your denial of any kind of access has to be only limited to those that fall under HIPAA, and that's those are if it's if you're a let's see. So if they're not reviewable, if the requests are made by inmates of a correctional institution, or it's information that relates to research that includes treatment, and there are also certain denials permitted under the PHI Act, just like for instance if the information or disclosure will be damaging to the individual who's requesting it, or cause other harm, which also fits the first exception. Okay, the next one is respecting individual's request not to share. So under HIPAA, a patient or an individual right now has the right to request that certain information not be shared with other people, and you're not, as a healthcare provider, the only ones you're required to comply with are the ones that relate to their payment in full for an episode of treatment or an episode of care. So in this case, this is a little different. So the actor, the individual requests that you do not share the information, then you're permitted to agree with that restriction and follow it, and you just have to make sure it's documented within a reasonable time after the request for restriction. Make sure it's applied consistently and in accordance with your policies, and then again, the restriction may be terminated, but it's only if the patient or the individual agrees to termination in writing, and oral it does give it by verbal agreement and that's documented, or if the actor informs the individual that it's terminated its agreement not to provide such access, and that would fall more under the health IT section. So this area right here does intersect considerably with HIPAA. So it's important to, again, review your HIPAA policies, your forms, identify where there might be some sort of interaction between your policies and your forms and the information blocking exceptions here, and update your policies in that regard. Okay, so the security exception is the next one. That's exception number 3. So you're allowed to restrict or not disclose information if you think it might be damaging or directly related to a safeguard you already have in place, and it's specifically tailored to that security risk. And also, again, with all of these, you have to implement them consistently in a non-discriminatory manner. So the idea is to make sure that if you fall into the security exception, that you do have good documentation. Again, just like the HIPAA security rule, which is intended to be flexible because everyone has a different setup and everyone operates differently based on their size and circumstances. So this also has some flexibility in it as well. So if you have organizational security policies that are in writing, that are prepared, in accordance with HIPAA and align with industry standards, then and provide some objective time frames, then you can, if your refusal to disclose information falls within those policies and is based on that, then you're allowed not to disclose information. Also, you can have a qualifying security determination. So if you don't have a policy, but it's a unique situation, you can do a case-by-case assessment as long as you meet these criteria, and that is that you have it in writing. It's based on specific particular facts and circumstances, and you demonstrate that it's necessary to mitigate the risk to the EHI, and that there are no other reasonable alternatives to the disclosure that would prevent and protect the information. So again, with this, it's just as with all this, it's very important to make sure that you maintain good documentation. Many of these exceptions allow you to do a case-by-case analysis rather than having a specific policy that addresses it, because they realize that you will have policies in place, but they're going to be situations that don't fit right in with your policy, and so they do permit case-by-case assessments. With each of those, it is really important to maintain the good documentation, because once this starts to be enforced, the patients can have the right to seek enforcement. Okay, so infeasibility exception. Okay. Sorry, trying to take the time real quick. So if it's just infeasible, or you just don't have the capability, the technical capability, or the resources to disclose the information, the government realizes that you just can't do that. So in that kind of a situation, you're required to give a written response to the requester, whoever that may be, within 10 days to receive the request. So it's important to have a really good policy around this that addresses the time frame and gives everybody notice that it's a pretty short time frame, and you need to be able to move quickly. Okay, so the first one really is uncontrollable event. So if you have, in Alabama, we have tornadoes, and that's terrible. So if a tornado took out my doctor's office, then that would be an uncontrollable event, and his office would not have to disclose the information to me if I requested it. So the same sort of thing. It includes, these are all natural disasters. Public health emergency is one of those which was added, and that's in a situation like this where we had a lot of the offices that had to close down and reduce staff. The ability to respond to patient requests for records, was difficult, and it did put people in a position where they weren't able to meet the request when needed, because they didn't have the staff available or the office was closed. So that is an exception. Segmentation. So if you're just not able to pull the information away from the other patient's information, so if the information the patient's requested or the other actor, maybe not necessarily a patient, but another actor has requested, and you're not able to separate it out, then that's an excuse. You have to have, again, you have to have writing that demonstrates these exceptions have been applied consistently and non-discriminatory. You have to identify the type of PHI and the purposes, the cost. If it's infeasible because it's too expensive, you have to identify what the cost is and what the financial restrictions are. So you have to, there's really a lot of documentation that goes into meeting each of these exceptions, but this is one that's in particularly would require some additional documentation. Okay, so health IT performance exception. So if an actor is not able to either the hospital is not able to provide the records, or someone else is not able to provide the records because the health IT system is down, it's being subject, undergoing regular maintenance or improvements, or make some other exceptions, then those are there are really three of those that can fit the exception. So maintenance and improvements to health IT technology, or health information technology. This is if it can only be, the technology can only be down for a certain limited amount of time as necessary, has to be a consistent and a non-discriminatory matter. So it can't be the technology has to, that downtime has to be applied across the board, really, to everyone. And if it's something that's initiated by the health information technology developer or by the health information network, then it has to be consistent with your existing service level agreement. If it's planned or if it's unplanned, it has to be agreed to in advance. So, of course, this does not address instances where there's been, maybe a cyber attack or something else. That would fall in the earlier exception, which is an infeasibility. So this is a, this is a plan. This is, an intentional denial of access to health information technology system. So assured level of performance. So that if there's if the use of a third-party application or some other kind of product negatively affects the performance of the health information technology, then you can refuse to license with it or allow it to connect to your system. But that's, again, has to be only for the period of time that's absolutely necessary, and it has to be applied consistently in a non-discriminatory manner and with the existing service level of agreements. Practices that would prevent harm. So if the conduct is something that would prevent harm to a patient or the person, then it must also comply with that first exception we talked about, the preventing harm exception. And so this would be, I guess, an example would be if disclosure of the information by the health information technology would result in damage to an individual. Security related practices, again, if the use of the health information technology would endanger the security of the information, then you have to comply with the security exception above. So for all of these, it's really important to, again, review your HIPAA security policies, look at your the service level agreement and service agreements you have in place for your health information technology service providers, and determine whether or not there are provisions in there that address these different exceptions. And think about whether or not you need to amend the service level agreement.
Okay. So the next one is can you hear me?
Yes, we can.
Good. Okay.
It's a little muffled though.
My head. What?
It's slightly muffled. It changed a little bit.
Yeah, my headphones are making a weird noise. Let me take them off.
Okay.
I'll just try to talk. Can you hear me now?
Yes, we can.
Yeah.
Oh, good. Okay, I'm gonna do that. You might hear a little background noise in the background, so if my dogs bark, I apologize. But
No
No worries.
2 golden retrievers, and they're inside right now. It's kind of rainy outside. So anyway, so the next one is the content and manner exception. And so with that one, if someone requests information requests a certain amount, certain content of information or an amount of information and you're just not able to comply with that, there are certain conditions that fall within that. So for the content condition, you have until so we talked earlier about the electronic health record, electronic health information, and also the US CDI standard. So from May 1st until May 1st, 2022, the amount of information that can be exported or has to be disclosed through the health information technology is limited to the US CDI, which we discussed earlier. But after May 1st, all of the information in the electronic health record has to be available to be exported. So that's going to require some pretty significant development by the technology companies. But they do have some time to get that in place. So these are, I guess, these next 3 conditions are really, these are exceptions that involve procedures for fulfilling requests to access, exchange, or use EHI. So not exceptions that say that permit you really necessarily to engage in it, but they identify how you fulfill the request to access information. So the manner of response is there's a condition on how you can respond to the information, so that the person can ask you to or the the requester can ask you to send the information within a certain way. So you have to fulfill the request unless you're technically not able to do it, or can't reach an agreeable terms with the requester. And if it's fulfilled in any manner requested, you're not required to comply with the fees or licensing exception, which we'll talk a little bit more in a minute. And you can negotiate a mutually agreeable fees or other terms. So it's to the extent that you can reach an agreement, it's really helpful. So if you can't fulfill the request and you can't reach an agreement, ONC says there are 3 other options, and they have to be applied in this specific order. So you have to use, if the requester has an alternative ONC certified technology that they specified, then you have to use that technology to deliver the records, or the information being requested. Also, and then if that's not available, then if the user has specified any other kind of content and transport standards that are established by ANC or the federal government, then you have to use those. And the third and last one is in an alternative machine readable format agreed to by the requester. So all of these are a little different. So now in our, when you terminate a health IT contract or a BAA, there are those standard provisions that you'll get your data back in whatever form. And so this does change that provision, and it gives you the ability as a provider really to be able to get the content, get your data back in a manner that really helps facilitate transfer of that information to a new vendor, and it makes it much it will make it much easier, hopefully, and less expensive. So the fees exception, and we talked I think about one of these earlier. So the fees exception is it's information blocking if you charge fees that don't fall within this exception. So the fees have to meet certain conditions, and so that's it has to be, the fees have to be objective and verifiable. They have to be reasonably related to the cost of the production of records. They have to be reasonably allocated among all similarly situated people, and that's really sort of they have to be applied consistently and non-discriminatorily. So that means that for all of these, you have to consider whether you're applying the exception or as in a non-discriminatory manner. I mean, it's across all similarly situated types of individuals or other healthcare providers. It has to be based on costs that are not already recovered for the same request. So, for instance, if the request is to provide information through an interface, and the interface cost has already been paid for as part of the development as part of a development cost, then the HIT provider can't also then charge you a fee for transmitting the information. It also cannot be based on competitive considerations. So sales, profits, revenues or other value that the requester thinks that you might get from, or that you might think somebody else might get from access or use of the EHI. Costs that the actor incurs because they have a proprietary or non-standard health IT information. We talked earlier about how the health IT is supposed to, they're trying to get it, have developers get to the point where everything is open and communicates really well. So that's some of the proprietary standards now do prohibit that. One of those is when you do access get your record, get your data from an EHR vendor. They may have a proprietary database, and they require you to pay a fee in order to access that database to get your data. The cost of intangible access, opportunity costs, and any costs that relate to IP or royalty fees are not that fall into the licensing exception. So the fees exception is going to require all the health IT developers and those that certify that are developing and certifying the API technology to comply with these different rules. So that's gonna require for them probably some some change in their contract structure and amendment of the contract. Okay, so next one is the licensing exception. And so this one is the licenses of the health IT can contain certain provisions and that will not be considered health information or health information blocking. So they two of the things though that are really the timing of a license agreement negotiation is the part that's going to be really difficult, I think, for everyone to meet. And that is that you have to, if there's a request to license a certain interoperability element like an API or a type of interface or other thing that helps facilitate the transmission of information, then the request, the actor, the person who's being requested to license this has to begin negotiations within 10 days, and they have to conclude the negotiations within 30 days. That's a as an attorney, I just know because I've negotiated these frequently. That's a pretty tight time frame, so it's going to be difficult. So I have two notes here that this doesn't really take into consideration the complexity of a license agreement. So if you're negotiating a really simple health IT that may help facilitate a communication with patients, as opposed to one that's an agreement with Epic or one of the large hospital systems that's hundreds of pages long, that's a little difficult. So so it's really important that if you've been requested to license a product, that you do maintain all the documentation and communication so that you can document what might have happened if there was a stalling of the negotiations and something happened that that led to restriction of it. Okay. So the licensing conditions are the scope of rights. It can have a restriction on rights for access, user exchange. You can impose a reasonable royalty that's non-discriminatory. It's based on the actual value of the product itself, and not on your or the actor's control of the access, user exchange. The license has to have follow certain standards, and you cannot impose a royalty if the development cost is already paid in compliance with the fees exception. So both of those have a sort of crossover there. Non-discriminatory terms, it has to be all the terms have to be objective and applied similarly across the board to all types of individuals. Can't be based on a competitor status or use interoperability. So it can't be used to help shore up someone's competitive status, and not based on the revenue that someone else might receive from access or use of the EHI. Also, so you can't have the types of terms that are not allowed there. So you cannot have a non-compete in the license agreement. You cannot have an exclusivity provision in the license agreement, meaning that you would only use that product or not use products of a similar type. Cannot have anything that ties the license of that product to you're being required to purchase another product for that same vendor. Can't do anything that would restrict transfer of the IP in the event that you have to you assign the contract, or you have to move the contract over with the new entity. And you can't have additional fees except for those that have been identified with the reasonable royalty amount. Now I don't know, that doesn't really discuss things like support fees and maintenance fees. I think those are probably not intended to be inhibited by that part of it. So a non-disclosure agreement, if there's a non-disclosure agreement that's entered into, then it has to be limited, has to specifically identify trade secrets, and there's a legal definition for trade secrets. So it can't just be, whatever information you want it to be, but it does have to include specifically limited only to that information that's considered to be the legal definition of trade secret. The additional conditions that are prohibited are: you can't have conditions in the contract that would impede the efficient use of interoperability elements, or impede the efficient development, distribution, or deployment or use of interoperability elements, or degrade the performance or interoperability of a licensee's product or services. So for both health IT developers and providers, it's going to be important to review license agreements to make sure there's compliance with the terms. And again, the health IT providers are going to have to amend their agreements going forward. So this will be something that will come up. So some of the practical considerations that apply to all of this are that, across the board, I think a really good thing to do is to develop some information blocking policies and practices, train your employees, and also look at your HIPAA policies and procedures, because there is significant amounts of overlap, and make sure that those two are not in conflict, and that your employees, your staff really understands how those are going to work together. You need to evaluate your current electronic health record technology and other technology to make sure that they meet the US CDI elements, that they do have the ability to export that data through the system as required. And that's coming up, that will be coming up pretty soon. Evaluate, revise, and create forms that, so for your HIPAA forms or any other forms you have, it's a good idea to go in and look at those, compare them to the information blocking rules and your policies, and make sure that you make correct adjustments in those forms to address the changes, so that you don't run into a information blocking situation. Revise and update your security risk assessment and risk management policies to address the risks that are going to come up when you're required to export the information to a place that the patient has requested. So this is anytime you have a significant change in systems, or a change in how you disclose or release patient information electronically, it is a recommended idea, and it's also something that OCR typically requires, and that is that you update your security risk assessment and risk management plans policies. The other thing that we talked about earlier is updating those privacy practices to make sure that you do also have the notice in there to the patients about what changes will be made, how the information will be available, and the fact that they have the right to review a decision regarding their request for information that's been denied. Update digital contact information in PPES, and I forgot to mention this earlier. So all providers are going to be required to update their contact information and include a digital an email contact, as well as like a URL or other kind of digital address in that system. So that'll be you need to update that, and if it's not updated, and by the time that the rule requires, then CMS does actually. That is another thing to add to their report on the provider compare page. MIPS reporting, make sure that when you do go through and do your MIPS attestation, make sure that you do correctly respond to information blocking statements and attestations. Evaluate all your technology contracts and SLAs, and then establish a documentation process. For each of these exceptions, it's very important to maintain the documentation, because if a complaint's filed, that just like with HIPAA, that is how you defend yourself and demonstrate that you did comply with the law. Okay, so the ONC complaint process, ONC is directed to establish a complaint process. They've done that. They're working on it. They haven't finished. So, but it'll be built on basically the same mechanisms as exist right now for a HIPAA complaint. So the patient or the provider or anyone that's engaged, that has been the victim of information blocking, can file a complaint, can be submitted anonymously if they want to. It'll be reviewed similar way that that HHS currently reviews complaints. OIG may also receive complaints, and if they do, they've also been trained, we hear, to identify information blocking when they're conducting an audit or an investigation for fraud and abuse. So that's something just to be aware of. But if they do receive a complaint or something, then they'll review it and then refer it to HHS. So as with all of this, it's a good idea to maintain documentation of all your compliance with the exceptions and also policies for at least 6 years, and in some places the rule indicates 10 years. So enforcement, OIG is tasked with enforcing the rule as well as referring the health. So the OIG will enforce the rule against health information technology developers, health information networks, and exchanges. And the CMPs right now under the statute are up to $1 million. So the OIG has not established, they've not finalized their civil money penalty rule yet. We don't really know what the categories are going to be, exactly how that's going to roll out. But the earliest it could possibly be finalized will be November 2nd, but it's probably going to be after that. That's what we think. And what the OIG is also tasked to do is if they identify a healthcare provider that's engaged in information blocking, then they refer that provider to the appropriate agency for appropriate disincentive. But that too has not been identified. CMS hasn't identified what those disincentives might be, and HHS hasn't either. So we don't really know exactly who will be the HHS enforcement agency and what the disincentives might be. But I imagine it's going to be kind of similar. I suspect it'll be similar to what they do with HIPAA, and but we'll find out, I guess, pretty soon. And so the OIG has identified some priorities enforcement. So the first one they want to do is they want to make sure that if the conduct involves patient harm, then they're going to investigate. If it impacts the provider's ability to deliver care, then they'll definitely investigate it. And if it's something that's extended for a long period of time or results in a financial loss for one of the federal programs, then they can investigate that as well. The other thing is that they're going to really, apparently they've said that we'll take a hard line on willful action. So when someone engages in information blocking that is with actual knowledge they're doing that, then they will consider that an enforcement process. Okay, so this is a note. This is not related to 21st Century Cures Act information blocking, but this is related to the CARES Act. So we've all the providers have gotten provider relief payments under the CARES Act. And part of what the CURES Act does is it amends the civil money penalty statute to extend False Claims Act to claims arising from HHS grants. Previously, that was not the grant. If you entered a false statement of grant, you weren't subject to the False Claims Act in the past, but that has changed. So the CARES Act that was enacted in March does amend the CMP to extend to HHS grants. So the CURES Act does. So under the CARES Act, provider, and this is confusing, CARES Act provider relief fund payment is considered a grant. And so when you made your attestation acceptance of the money and you've used the money and then you report on the uses, all that documentation, all those statements to the government are now sort of part of the grant process and can subject you to False Claims Act liability. So bottom line is, in any of that, keep the funds, keep good documentation of the use of the funds, maintain it for at least 6 years, and have it available if you need it for an audit. Okay, so the last other part of enforcement is you got the OIG, so there's CMS public reporting. CMS won't fine the individuals, but they will publicly report clinicians, hospitals, and clinical access hospitals that may engage in information blocking they'll put those, put that information up on their pages, and they'll also list and identify providers that do not update and list their digital contact information in the National Plan and Provider Enumeration System. So it's important to go ahead and update that with your email address, and then make sure your IT department has the correct information on there for the other types of address that need to be uploaded. All right, so that's it. I've got a few minutes for questions.
There was one. Oh, sorry.
That's okay.
It looks like Beth, I'm going to put you on mute for just a second so it doesn't echo. It looks like we had a question, and it says, if a business falls under 42 CFR Part 2, is the business allowed to send a text to a patient that shows the day/time of their appointment without mentioning any PHI? What about sending a text to a patient that their prescription was sent to the pharmacy? Okay, now I'm going to unmute you. There we go.
I would say that under Part 2, then you need to have the patient's consent to be able to do that. And to the extent that you're sending any information that is regarding a prescription, in that case, my recommendation would be it needs to be in an encrypted text or secure format.
Great. Does anybody else have any questions? I don't see any in the chat box, but if you have any questions, feel free to unmute yourself and speak up if you'd like.
Yeah, I left a little bit of time because the whole 21st Century Cures Act is a lot of information, and it's confusing. So if you have questions, you're welcome to email me. My email address is on this information, or call me. I'll be happy to talk to you. But it is a big change. It's a lot of information, and it's it's going to happen quicker than we expect. So.
Well, Beth, this is Carol Moser. I'm the Executive Director of Greater Columbia ACH, and I just wanted to thank you for hanging in there. From Birmingham, Alabama, it must be kind of late back there, so we really appreciate your time today and sharing all this information with us.
Well, you're welcome. It's my pleasure.
Okay, have a wonderful weekend.
Thank you.
Thank you.
Bye-bye.